We're live.
All right, good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Thursday, February 10th, 2022. We have 10 bills on the docket, and we'll start off with Senator Huff, Senate Bill 287. We'll then go to Senate Bill 392, 397, 389, 277, 319, 327, 382, 356, and 339 with Senator Huff again. So with that, is Senator Huff up and ready? Sandy, I don't see Senator Huff.
Senator Huff is in the process of logging on. Just give him 1 second.
Okay. I would tell the dad jokes, but we're live now, so save those when we're offline. While we're waiting, the Chief Judge didn't hear this one last time, so we can go and recycle a few goodies. Is that okay? All right. So we started off with what type of socks do pirates wear? Argyle. Solid. All right. Then you follow that up with what is a pirate's favorite letter? You would think it's the R, but it's really the C. See what you did there? See that? That's good, right? You know, lay the foundation. All right.
I'm just going to start letting the witnesses in for the second bill. So if you want to get started.
That's my prompt to stop telling jokes. All right. All right.
Oh. Senator Huff is in the waiting room. Okay. He's here.
All right, Senator Huff. Hey, what's going on? You're up next. We've already done the intros. So we're going to start off with your Senate Bill 287. Are you ready to go?
I've actually got Senate Bill 339 ready. Can I start with that one?
Let me see if the witnesses are here.
I don't have the witnesses. I've got the witnesses for 287.
Okay. Well, let me start. I'll do 287. It's a simple bill, and I know Judge Morrissey's here. He can explain it too in detail. Essentially, when we did the Justice Reinvestment Act, we were trying to deal with the issue of technical offenses, and we did the right thing in that we didn't want to reincarcerate people who had done a technical offense that was not a new offense. So, example, a dirty drug test or a missed an appointment. We didn't want to reincarcerate people for that. That was the point of the Justice Reinvestment, in that we're not going to reincarcerate folks for minor offenses. And one of the problems, and quite frankly, it became apparent right after it passed, and we've not been able to, unfortunately, address it. We passed a bill last year through the Senate, and we didn't get it all the way through, which was the idea of absconding and treating absconding as not as a technical offense. So if someone is sentenced to drug treatment and they abscond, if the only recourse is 15 days, what's happening is they're making the decision, hey, I'd rather do 15 days. I can do that standing on my head than face real penalties. And so we got to say that if you're sentenced to drug treatment, if you're sentenced to one of these mental health programs, which the idea of these is diversion in nature. But the only way a diversion program works is if you have real consequences on the other end. And so the fact that we've had and that we've been treating absconding as if it's a technical offense, that just has not worked. And people are not treating it like there's a real consequence for leaving these programs. And so we're taking and we're devaluing a diversion program. And unfortunately, when they walk away, some of them have gotten in criminal trouble later. and it really undermines the program. And the idea, I should say, this is somebody who's the author of the technical offense matrix and everything else like that. We knew going back, we may have to make changes and adjustments. And I think this is clearly, you'll hear from the State's Attorneys Association. I know the Office of the Attorney General has done good testimony on this. I know Chief Judge Morrissey is well versed in this. There is an amendment that we worked with Judge Morrissey on this, which would expand it to some of the mental health programs as well. So with that, I'll turn over to the panel.
Excellent. Thank you, Senator Huffman. We'll turn to your panel, and your first panelist is Chief Judge Morrissey. Chief Judge Morrissey, you're up. Welcome.
Good afternoon, Chair and members of the committee. For the record, my name is John Morrissey, and I'm the Chief Judge of the District Court of Maryland. The judiciary supports Senate Bill 287 as amended. To understand why we support this bill, I ask you to start with the premise that drug courts and all problem-solving courts practice rehabilitative justice. These specialty courts favor treatment in lieu of incarceration. In the lead up to the passage of the Justice Reinvestment Act, there were many discussions regarding exempting drug and other problem-solving courts from JRA, as these courts already use a graduated sanction method before any type of serious sanction is imposed. And it's really, the methodology is the same as the basis for JRA. And, we were hopeful that it wouldn't make it in there, but there was a crazy Saturday before sine die and it was left in. This has caused some issues, as Senator Huff mentioned, for the problem-solving courts, because they do not call their hearings technical violation hearings. They rely on their graduated sanctions, again, just like JRA does, but do not paper the case by detailing each sanction as a technical or non-technical violation. Please remember that these are all voluntary programs entered into by the defendant. Recent appellate cases have found that leaving treatment despite the court-ordered placement is a technical violation and subject to the presumptive caps for violations of probations in JRA. As the foundational underpinning of these drug courts is placement for treatment, we believe that leaving such treatment is not a technical violation, but rather is a non-technical violation. It's considered a very serious violation by the judge in the court program. These individuals have simply walked away from treatment in violation of the very purpose of drug court to get them treatment. Senate Bill 287, in my opinion, fixes this issue. I thank you all for your consideration. I urge a favorable report for 287. And I just have one question for you, Chair. What did Della wear?
I don't know.
Idaho, she wore a New Jersey.
That's good. Another joke from the arsenal. There you go.
I'm sorry I subjected the committee to that. And with that, I'll be happy to answer any questions.
We know what's happening with this bill now. I don't know. All right. All right. Next, we'll go on to, thank you very much, Mr. Chief Judge. We'll now go to Mr. Riley. I see you here.
Thank you, Chair Smith, Vice Chair Wallstreicher, members of Judicial Proceedings. My name is Joe Riley. I'm the elected State's Attorney for Maryland County and the Legislative Chair of the Maryland State's Attorneys Association. We seek a favorable report on Senate Bill 287 and like to thank Senator Huff for his sponsorship of this bill. Maryland has been attempting to reduce selectively its prison population and use the resultant monetary savings to provide treatment to offenders before, during, and after incarceration. That's a quote from Conaway versus State, a 2019 case, but in simpler terms, it can be said as a shift in philosophy from the jail bed to the treatment bed. In the years following the Justice Reinvestment Act becoming law, the State's Attorneys Association has seen a pattern in incarcerated individuals being placed in treatment facilities pursuant to Maryland Health General 8507, and those individuals walking off from the treatment facility. Due to how those sentences are modified, the incarcerated individual, when they are placed into these facilities, are under the supervision of the Department of Parole and Probation. And as a result of that, these are termed technical violations and subject to the 15-day sanction limits described in Maryland Criminal Procedure 6223. This creates a perverse incentive to an incarcerated individual who has been given the option of treatment. They can stay in a placement and continue the hard work of sobriety, or they can walk off and be subject to a 15-day maximum penalty, be continued on supervised probation, and not have to return to the treatment facility. This proposal will change the definition of absconding as defined in Maryland Correctional Services 6101 to include leaving a placement facility without the permission of the facility. This definition of absconding has only been in the Maryland Code since 2016. And as the senator said, when it was passed, it was assumed that we would have to revisit this at some time. And we think this change in the law would help it make this desire to have people getting treated rather than incarcerated more capable of being accomplished. Thank you.
All right, thank you, Mr. Riley. We'll now move to Ms. Williams. 1 second.
Thank you. Thank you, Chairperson Smith, Vice Chair Waldstreicher, and members of the committee, and thank you to Senator Huff for introducing this bill. The Attorney General urges this committee to issue a favorable report on Senate Bill 287. I actually handled the case Brendoff versus State that was the appellate opinion that interpreted the JRA in the way that creates this problem. And what Brendoff said was when an inmate has his sentence suspended in lieu of inpatient treatment, the supervising authority is the Department of Parole and Probation, not the treatment facility to which the inmate is released. But often the inmate will walk away, or the probationer at that point will walk away from the inpatient treatment facility, and the probation agent won't know. What the Brendoff court said is that that's not absconding. It's a technical violation subject to the 15-day first technical violation incarceration caps. So I think this bill just fixes that problem. And for all of the reasons mentioned by my fellow panelists, we urge a favorable report. And I'm happy to answer any questions specifically about the case and about the interpretation of the JRA that led to this issue. Thank you.
Excellent. Thank you very much, Ms. Williams. All right, we'll now go on to Mr. Smith.
Thank you, Mr. Chairman, committee members. Charlie Smith, State's Attorney out in Frederick, speaking on behalf of NDAA as well. As Senator Huff indicated, JRA was a great thing. It was much needed. A lot of intended consequences came to fruition. Unfortunately, this is one very big unintended consequence of JRA. And so what we're seeing now is a huge loophole in the law. I mean, these defendants aren't getting backup time. We see people applying for 8505, which we all know is in lieu of incarceration. And we're talking about the people applying are DOC offenders. They're not misdemeanor offenders. They're usually felony DOC time offenders. And so they see this loophole. And we've talked to a lot of agents, talked to our narcotics prosecutors, and we see people now applying for 8507 that have really no intention of going through a program long-term. They now know as long as they get their 8507, they're going to go into this program, they're going to walk off, and the only thing the court's going to be able to do is give them 15 days. They do not face the full backup time. And so that's a problem. And that's a problem that this bill would solve if we pass it. So obviously we want a favorable report. With a non-technical violation, a judge would then have the authority to return that offender back to DOC, where they could serve whatever backup time they have. So really the need for this bill is twofold. One, we need to really incentivize the real addicts who have real need for treatment programs. They'll stay in their program if they know this is not just a 15-day penalty. We also need to disincentivize these people who are not truthful in their applications or their petitions for 8505, 8507 motions, and are really taking advantage of a massive loophole in the JRA law, sort of feigning, I guess, the need for these programs. So once again, Mr. Chairman, I would recommend a favorable on this one. Thank you so much for listening to me.
Thank you very much, Mr. Smith. And with that, that'll conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel, and we'll start with Ms. Hilliard. There you go. Up. One more time. There you go.
Thank you, Chair, members of the committee. Elizabeth Hilliard with the Office of the Public Defender. Our position on this bill, we're urging an unfavorable report because we think that it broadens the scope of the definition of absconding too far in the other direction. I personally have represented numerous clients who have sought out treatment through a 507 programs, and it is not unusual for someone who is going through drug treatment programming to struggle with their sobriety, to struggle with their mental health, and to have other issues come up that could cause them to briefly leave a facility or, regret their decision to go into a drug treatment facility and want to return, but could become afraid to do so because they are afraid to be found absconding, as opposed to being found that they have just, made a mistake, left. And so we're urging that if we work to fix this loophole, we don't do it in this way. We give the court more discretion, perhaps, in the way that they choose to evaluate how someone has departed from a facility, but not that it's automatically defined as absconding when someone departs from a facility, because there's a wide range of circumstances under which it would be inappropriate to penalize someone who, like I said, makes a mistake and then tries to return, but then because of this definition and because of the way the statute is amended or proposed to be amended, would be found to be an absconsion. So we ask an unfavorable report on this, but would be willing to discuss further options.
Excellent. Thank you very much. All right. With that, I think, Sandy, I think that's the end of the panel. Is that correct?
Yes.
Okay, excellent. So that'll conclude the testimony for Senate Bill 287. We'll now switch over to the committee for questions. Senator Sidnor, you're up.
Thank you very much. And I came in just at the tail end of Judge Morrissey's testimony, so this may have been covered, but because one of the proponents, I'll say maybe from the state's attorney's office, explain what does leaving mean?
I'll grab
Mr. Smith, maybe?
All right, Mr. Smith, there you go.
Thank you. Senator Sidnor, your question is, what you mean absconding, correct?
No, it says within the definition, it says absconding includes leaving an inpatient residential treatment facility. So I'm just wondering, what do we mean by leaving?
Leaving the facility, what we've seen means a walk-off, for lack of a better way. It doesn't mean that they somehow are seeking not to continue it or go into a different program. So we're seeing complete walk-offs. They don't come back from the program at all. And they could disappear for a number of months. And matter of fact, they often do, knowing the fact that the worst thing that's going to happen to them is 15 days. So they walk off.
Okay, so we're not just talking about somebody that might be gone for a couple of days. I mean, I'm trying to figure where this is on the continuum in terms of leaving.
No, we're seeing complete walk-offs where they don't come back for several months unless they reoffend. Of course, we pick them back up a lot of times once they're reoffending, which we're seeing a lot. So I don't think this is meant for the person that goes to see their mother for a day or two. I think that we're talking about people that are under the standards of the program are deemed to have quit and voluntarily absconded from the program.
Thank you.
Excellent. All right. Thank you very much, Senator Sidnor. We'll now switch over to Senator Hedelman.
Thank you, Mr. Chairman. I'm just going to follow up on that line of questioning. So if somebody does go away to see their mother for a day or two and then comes back, if this law were to pass, this bill were to pass, would they then be charged with absconding and suffer the consequences? You can, yeah, I guess that's the question.
Okay, I know that let's go, Ms. Williams can respond. Still on time?
I have the hardest time with that. I'm sorry. So the definition is leaving without the administrator's permission. So first, the administrator would have to either not know or not have given permission in your hypothetical of the patient leaving to go visit his mother. But the other thing to remember is this bill doesn't tie the hands of the violation judge or the agent. The agent still has the discretion to decide whether to violate the probationer based on that leaving. And even if the agent decides to violate the probationer, the judge still has the discretion to look at that incident and say, to the public, to my friend, the public defender's point, this incident was a mistake. It was part of relapse. I mean, it was part of getting sobriety. It was a relapse. It happens. I'm going to either not violate you or give you a much shorter penalty akin to a technical violation. There still can be a smaller sentence imposed for this kind of violation, like the technical violations limits. It just wouldn't tie the hands of the violation judge to a technical violation, rebuttable presumption limit on the incarceration. So, yeah.
Thank you.
Over to the Chief Judge.
In one of the two appellate cases that have addressed this issue, the individual actually had 6 prior times of drug treatment. So, the drug court judges don't want to. That's not the idea behind the whole treatment program. We want treatment, not incarceration. But the judge in one of those 2 particular cases had bent over backwards over a course of like 3 to 5 years, I believe, if I remember the case correctly. And this was the 6th or 7th time. So that's why the judge did what the judge did in that particular instance.
Excellent. All right, Senator Hedelman, good to go? Okay, great. Looking around the room for additional questions, seeing none, that will conclude the hearing for Senate Bill 287. Thank you very much, Senator Huff. All right, next we'll go to Senate Bill 392, and to introduce the bill, we will switch over to Mr. Mitchell from the Governor's Office. Welcome. There we go. Try to unmute one more time. There you go.
It was not. There you go. Thank you. Good afternoon, Mr. Chairman, members of the committee. I will be very brief. For the record, my name is Kiefer Mitchell, Chief Legislative Officer for the Governor. And joining me also is Aaron Chase, Deputy Legislative Officer, who will walk you through the bill. We're here on Senate Bill 392, Judicial Transparency. And we're here again to present this bill as an emergency bill to help bring transparency and accountability to our entire criminal justice system. Since he was elected, Governor Hogan has fought to bring transparency and accountability to state government. These same standards of transparency should apply to all 3 branches of government. As legislators, each of the votes you take, floor votes, committee votes, even committee amendments, are made available to the public. Since the pandemic, even more transparency has been introduced to the legislature, including video stream floor sessions and committee votes. The decisions made by public officials in our judicial system, in whom we trust our safety and liberty, should fall under the same standards of transparency. The lack of transparency promotes distrust and insecurity. Victims of violent crime need and deserve to know how long an offender is going to be put away. With that being said, the governor would urge a favorable report on Senate Bill 392. And at this time, I'd like to turn it over to Aaron Chase. Thank you.
Excellent. Thank you very much, Mr. Mitchell. We'll now switch over to Ms. Chase. If you can unmute yourself. There you go.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Senate Judicial Proceedings Committee. As Kiefer said, my name is Aaron Chase, Deputy Legislative Officer with the Governor's Office. We're here to respectfully ask for your support and favorable vote on Senate Bill 392, the Governor's Judicial Transparency Act of 2022. Maryland citizens expect and deserve transparent and accessible government across the 3 branches, which includes the judiciary. Given the historic rise in violent crime, we must take a holistic approach at understanding how and why these crimes are increasing. This requires additional reporting and access to data related to the sentences our judges are giving offenders of violent crimes. Senate Bill 392 will require the Maryland State Commission on Criminal Sentencing Policy to provide in its annual report for each crime of violence, the crime the defendant is convicted of, the sentence imposed, the applicable guidelines range, the case's disposition, if applicable, the amount and percentage of time suspended, departure reasons if a judge departed from the guidelines, the court and judicial circuit with jurisdiction, and the sentencing judge. The Sentencing Guidelines Commission already publishes most of this data by circuit, but by expanding the reporting requirements, Marylanders will have access to information that will better help them understand the judicial branch and how sentences are being determined. This bill simply seeks for additional data to be reported, data that again is by default available for public consumption. The bill does not make the sentencing guidelines mandatory, nor does it require judges to alter their sentencing behavior. The second element of the bill relates to changes to plea agreements. Currently, an MSCCSP binding plea is deemed guidelines compliant if it is agreed upon by all parties, the defense, prosecution, and judge, and contains an agreement to a specific amount of active time, regardless of if the agreed upon sentence is within the applicable guidelines range. Our bill would change the current law so that a plea agreement is not considered guidelines compliant unless it falls within the applicable sentencing guidelines range. This is an important and necessary change because current data suggests that 42% of cases were disposed of using a binding plea and 81% of cases were considered guidelines compliant. The opposition today may state that they feel that the bill is unconstitutional, but it is not, because it in no way changes the way a judge sentences or requires them to change their behavior. All it does is take current public information and requires it to be compiled in a way the public might find useful. We argue that this is good public policy, but the judges may argue otherwise. For these reasons, the administration respectfully requests a favorable report on Senate Bill 392.
Thank you very much. All right, so that's the testimony for the proponents of the bill. We'll now switch over to the opposition panel, and we'll start off with Chief Judge Morsi. There you go.
Okay, thank you. Good afternoon again, Chairman and members of the committee. For the record, my name is John Morsi, and I'm Chief Judge of the District Court. There are two cases that I proffer as an example of the problems with this bill. The first case involved a woman in her senior year as a church lady who sang in the choir and had no prior criminal record. She came home one day to find her husband with another woman and picked up a 2x4 that happened to have nails in it and beat each one of them. She was charged with assault in the first degree, but at the preliminary stage, the case was marked down to an assault 2, which occurs pretty frequently in district court. She pled guilty, was remorseful, and sentenced to a suspended sentence with probation, but with no active jail time. The second case is also an assault assault in the first degree that came before me that was written down to an assault in the second that involved a knife and injuries. The individual, however, had a lengthy criminal record, including prior convictions for crimes of violence, and was out on pretrial release at the time of the incident. In that case, a significant sentence was imposed. These two assault cases show how wide the variations can be and how inappropriate comparison would be. If you looked at these two cases without looking into the case file or watching the proceedings, you'd not be able to figure this out. The judiciary strives, you've heard this is a transparency bill, but the judiciary strives for transparency in many ways, as every courtroom is open to the public every day. We record everything we do, and anyone can request a transcript or recording of these hearings. And there are other checks by means of appeal if they believe a judge has gotten it wrong. And if they believe the judge is acting improperly, we have accountability through the independent body of judicial disabilities that investigates any issue raised with judge improprieties. Further, as an administrator in the role of chief judge, when I receive a complaint regarding the conduct of a judge or commissioner, I pull the file, listen to the recording, and I promptly address the issue if needed with the judge and local leadership. If the question is asked what this data would do if released, it seems likely that it would be used to criticize a judge that, depending on current sentiments, could be that the judge was too tough on crime or not tough enough. But we're not supposed to be tough on crime or lenient on crime. Judges are supposed to be fair and apply the law to the unique facts and circumstances of each case. Thank you for your time, members of the committee. I would urge the committee to vote unfavorably and would be happy to answer any questions. Thank you.
Excellent. Thank you, Chief Judge. All right, we'll now move on to, is Judge Avery here? Sandy, I don't see the judge. So we'll move on to
I don't either.
Mr. Wilson. Judge Wilson. Ah, good to see you. There you are. Welcome.
Thank you, Mr. Chairman. It's good to see you and then the other honored members here as well. I, along with Dr. David Soule, who's also on your screen, are here on behalf of the Maryland State Commission on Criminal Sentencing Policies, in other words, the Guidelines Committee. We are the organization that would be directly affected by the bill. We have a large and diverse membership. We are an independent body. 2 years ago, when this bill came before us, or came before you, the commission did have a very long and robust debate about what position to take, and ultimately did come up with a position of opposition. This year, the commission did meet Tuesday night and did arrive at the same position, basically because the intent of the bill and the original purpose of the commission do not seem to jive. The commission is a nonpartisan group that is tasked with putting together the information from across the state on criminal sentencing, most primarily from the circuit court, and take that sentencing and put it into meaningful statistics and ranges based on the nature of the charge, whether it be property, person, drug-related, or violent. Those numbers are then weighed by the staff, and I can tell you that the staff of the Maryland Sentencing Commission is one of the hardest working staffs I've ever been involved with. And what they are able to do is take those numbers, put them into a range that all judges can look at, so they have a better idea of how sentencing policies are going across the state, county by county, and circuit by circuit. As a commission, we do not take a position as to, again, the intent of the bill, only as to whether we are the appropriate vehicle for using or for putting the transparency provisions in place. Dr. Soule can answer more questions about the technical aspects and the additional work hours it would take in order to try and maintain the bill. One other quick note, and then I'll end. Our position paper was submitted. It's only a page long. As to the binding pleas, I would simply say that within the last 2 years, since the last time, we have come up with a firm definition for the first time of what a binding plea is. Previously, it said only an ABA binding plea. I can assure you, as being a prosecutor in my previous life, that there is no such thing as an ABA binding plea. It was simply a name without a definition that was thrown into the regulation, but anything could be claimed to be a binding plea. We instead have put standards in to make sure that a binding plea is in fact a binding plea where a judge has willingly and using her or his discretion has joined into that outcome, as opposed to simply accepting a plea between state and defense. With that, I'll stop my testimony. If there are any questions, again, especially as to the mechanizations of the sentencing guidelines, Dr. Soule is here and is a wealth of knowledge. Thank you very much for hearing us.
Excellent. Thank you very much. All right. So with that, we'll switch over to Dr. Soule. Just take a second to realize that Senator Sindor, Senator Carter, and you and I were all in the same committee at one point in time. Small world. All right. Doctor, you're up.
All right, thank you. Good afternoon, Chairman Smith and Vice Chair Wallstreicher and members of the Senate Judicial Proceedings Committee. My name is David Soule. I am the Executive Director of the Maryland State Commission on Criminal Sentencing Policy, or we just call the Sentencing Commission, or MSCCSP for short. Thank you for the opportunity to speak today regarding Senate Bill 392. I won't reiterate all the points that our chair, Judge Wilson, already made. I appreciate having the opportunity to speak about this. As he noted, the commission met on earlier this week and did vote in opposition to this bill. I mainly signed up today, so I may address any questions that you have about the functions and activities of the commission. I just will note that in the fiscal and operational statement that we submitted, the legislation does have both an operational and fiscal impact on our agency. And I won't go into the full details on that unless there are specific questions, but it would necessitate changes to the Maryland Automated Guideline System, which is the online application that is utilized for the initiation and submission of sentencing guidelines worksheets. There's also additionally a need for additional staff to meet the the new reporting requirements from the legislation. So I thank you for the opportunity to speak, and I'm happy to answer questions if they come up at the appropriate time.
Excellent. Thank you very much. All right, next we'll go on to Mr. Weiss from UP. Welcome.
Yes, good afternoon, Chairman Smith, members of the committee. Thank you for the opportunity to testify to express my concerns about Senate Bill 392. I bring two perspectives to this topic. First, before I became a law school dean about 10 years ago, I worked in Washington in various capacities and was heavily involved in the federal sentencing guideline system. That was a very rigid, mandatory system in which judges were pressured to sentence within very narrow ranges for different kinds of crimes and different offenders. That system ultimately was found to be unconstitutional by the Supreme Court, and it is now advisory. But it's an object lesson as Maryland considers sentencing in our state. It would be unwise, I think, for the committee to pass legislation that would effectively pressure judges to sentence in a certain way. Judges should be free to impose just sentences. As Judge Morrissey said, they strive mightily to do that. My second perspective is that of a law school dean. As a dean, I feel very protective of the Maryland judiciary. I'm impressed with the earnestness and skill with which our judges apply the law, and judicial independence is a bedrock of our democracy. We tell our students that in law school, and I think that this bill infringes on the prerogatives of the judiciary to publicize information as it thinks best and most effective. I fear that the kind of report that the bill calls for would effectively be misleading because there are so many factors that contribute to the imposition of a sentence that couldn't be captured in the cold report. And therefore, judges would unduly be pressured and criticized and vilified for doing their jobs. I think that's unwise, and I encourage the committee to not report this bill favorably. Thank you, Mr. Chairman.
Excellent. Thank you very much. All right. Next, we'll move on to Ms. Smith. And then, Smith's not here. And then Ms. Mundell, Hanson Mundell, you're up. Welcome.
Good afternoon to committee members. My name is Nicole Hanson Mundell. I am the Executive Director of Out for Justice. First, I want to echo the comments of Judge Morrissey and just really talk about, labeling. One, this bill really restricts and discourages consideration of mitigating circumstances, right? The bill would limit the discretion and flexibility of judges who wish to remain compliant with the guidelines. Labeling plea sentences below the guidelines as non-compliant will discourage judges from considering alternatives to punitive interventions, even when such interventions may be more effective in preventing recidivism. This bill threatens to put political pressure on judges. Judges are selected for their impartiality and ability to weigh in complicated circumstances. The commission judging these statistics, which is the Maryland State Commission on Criminal Sentencing Policy, is composed of political appointees who are likely to interpret these numbers through the political bias. The governor, a single politician, has outsized the influence on this commission by appointing 9 out of the 19 voting members, in comparison with the chief judge of the Court of Appeals, which only has 3. The Senate president only has 2, and the speaker has 2. We won't get into, the clear bias that this governor has on Baltimore City, but we do know that these kind of same racist strategies were used for decades, right? Politicians in the 70s and 80s and 90s explicitly called out inner city crime and to garner kind of support from fearful white people. This is really the wrong focus and the wrong strategy. We have to understand that members of my org, William Friedman, who had a violent crime, who is now going on to get his doctorate degree, Earl Young, who is on the ground in Baltimore right now, going into schools, supporting young people. It requires us really to see people individually throughout their whole process, including during sentencing, the mitigating circumstances, the access to healing and growth, that supports people behind the walls and providing support upon release. And so this really, and I'll close up, but this fuels crime and mass incarceration when people are all sentenced the same way without recognition of the facts and motivations, locked away for years in terrible conditions without opportunities to heal and grow, and released without any support or and denied opportunities due to their lack of prior record. And I'll end on saying this: if the governor wants to focus on anything, he should really be focusing on figuring out how we fund women's pre-release, how we ensure that monies are being allocated
Ms. Mundell.
to assure that women who are coming out of our prisons and jails have access to wraparound support. This can begin to reduce recidivism.
Excellent. Thank you very much. All right. Now, that will conclude the testimony for Senate Bill 392. We'll turn it over to the committee for questions. Senator Carter and Senator Hedelman have questions, so we'll start off with Senator Carter.
Thank you, Mr. Chair. My question is for either Mr. Mitchell or Ms. Chase, I suppose. Reading through the bill, so there's two basic issues. One is the issue of transparency, which we've heard that there could be some difficulty with the administration of that. But I think, this is information that's already public anyway. And so figuring out some kind of way to condense the information is probably not that problematic. But the part about compliance, whether a sentence is compliant, I don't see, maybe I just didn't read thoroughly enough. So what is the repercussion for a sentence deemed non-compliant? It says that it won't be used to do anything to the judge. So what will happen?
Oh, Aaron, do you want to take that or you want me?
I can take it. Senator Carter, thanks so much for your question. That provision of the bill we put in there to kind of really just get better data on the use of these binding pleas. We don't intend for that language to impact a judge, defense, or prosecution's ability to use a binding plea. So there wouldn't be any negative impacts to it as I understand it. It would just be considered non-compliant in the Guidelines Committee's report.
So no, I agree with some of the testimony. I think just labeling non-compliant without further explanation is somewhat problematic. I think that we trust judges to use discretion to make decisions. Guidelines are there for guidance, not to be always strictly adhered to. So I just believe that in the effort to promote greater transparency, there should be some accommodation. If we're leaning toward choosing to go this route, some accommodation for explanation. I think explanation is always important, and understanding what led to that decision is critically important. But just to say non-compliant or compliant based on the following of a guideline, that just seems to me to be just, first of all, not getting to the root of what we might be trying to get to. And absolutely having a detrimental effect on judges that are now in considering the best decision going to be, well, I don't know if I want to be labeled non-compliant. So I just think that's a poor use of I think that's not the right terminology. And I think that's not the right way to get to what you want to get to. Transparency, we understand. I think, first of all, it's already transparent because courtrooms are open to the public except for juvenile, and or they're sealed for some other kind of reason. So this is already public information. I think that maybe we can work on how to make it more easily accessible in a data system. That makes sense. But I do think this is an overstretch with the labeling of a judge as non-compliant. And I'm wondering if there's some amenability to, should we choose to go this route, expanding upon that and allowing for, a full explanation of the circumstances and facts and what, as Judge Morrissey said, what were the circumstances in the situation, the person's life that caused the judge to do that. And finally, that just reminded me with what Judge Morrissey said, he compared the two situations. And of course, the first thing that came to my mind in the explanation of the different outcomes for two different people is race and gender, because I always think those influence a lot of outcomes. And so I do think if we're leading into this direction, we need to absolutely include those factors in any kind of transparency effort. And so that's questions and comments rolled into one. Thank you for the time.
Thank you, Senator, and we take to heart your comments and your question, and we look forward to working with you on a amenable amendment.
All right, thank you, Senator Carter. Senator Heddleman and then Senator Castley.
Thank you very much, Mr. Chairman. I guess I would like to direct this to Mr. Soule and or Dean White also. You mentioned, and I totally agree with my colleague's assessment and your concern that this would just be sort of a stark accounting. This judge decided, these were the facts, and this is how they either were consistent with or deviated from the sentencing guidelines. But if there were some way to provide some context into, for example, shedding some light on the two examples that Chief Judge Morrissey provided, I guess I would like to know, one is whether that exists currently when judges complete, I assume they have to, and I think the bill says they have to complete something with regard to whether they're compliant with the sentencing guidelines. And do they have to say if they're not, why they're not, or do they have to provide any sort of narrative or explanation now, currently? And two is, what would you think if there were an ability beyond sort of a stark data collection process, but a more holistic, way where a judge could provide some explanation and context to the decision-making process, kind of what your thoughts are on that.
Dr. Soule, do you want to answer first?
Sure. Just the question was the guidelines do ask judges to document the reason for departure from the guidelines when there is when it is a case that is a departure, and there are some common reasons that are provided as drop-down options that just is a kind of a quick way for judges to be able to document the reason that is provided for the departure. And then there is a text field, which they can always utilize to provide additional details about the rationale for the departure if they would like to do so.
And do people do that in your experience?
Yeah, so it is a mandatory field. So if it's a departure, there has to be some answer provided. It's much more common for the judges to select from the common reasons for the judge, and those being that it was a recommendation of the parole and probation or state's attorney's office, or that it was a plea agreement. And so that reason, that it was a plea agreement, it does leave out some additional details about still why potentially there was an agreement, for instance, to a sentence below the guidelines.
I would just add, Senator, I think that the judges can be trusted to disseminate information in an appropriate fashion. And I would leave it to the judiciary rather than legislating this kind of call for transparency. As has been said, courtrooms are open. It's expected the judges provide reasoning for their sentences, especially in a plea agreement. It often is the product of a negotiation involving the state's attorney's office. And the explanation can be provided in a fashion that the judiciary thinks best. I think it's appropriate to leave it to the judiciary to determine the right mechanism.
Thank you. And if I could ask, Mr. Chairman, do you think it would be possible, or Dr. Soule, would it be possible to get or share with the committee what judges are required to complete, what paperwork they're required to complete as a follow-up to their decisions right now? Is that something?
We can do that. We can provide that to the committee.
Great, that would be helpful. Thank you.
Doctor, we'll reach out to get any of the information.
Absolutely.
All right, Senator Castley, and then we'll go to Senator West.
Thank you, Mr. Chairman. Judge Morrissey, Judge Wilson, Dean, Mr. Soule, welcome to Judicial Proceedings Committee. Thank you all for coming in and for your excellent testimony. Very much appreciated. So I'm just going to state what my concern is, and maybe you can help me come to the bottom of this. Although I will say this at the front that I look forward to an opportunity to try to craft legislation that is meets the need, and I'm not wedded to the particular verbiage in this bill. Glad to see what we can do to come to an accommodation. Here's my challenge: is that historically, people knew what happened to a criminal defendant. It was, from the founding time of this country and for most of our existence, it was pretty easy to trace what happened to the defendants. And for every case, and it was pretty well known in the community. And certainly in some of our smaller jurisdictions, that's still the case. People know what happened in those cases. But the challenge we have now is that with the proliferation of crime of all sorts, with the lengthy delays in the sentencing processes, which I realize are for a myriad of causes. We have to get pre-sentence investigation reports and the court delays because of the extreme volumes that you're facing. And also because we've now adopted this endless sentencing policies in the General Assembly that basically says your sentence is never done. All that and more has resulted in a situation where we just don't know. The public doesn't know whatever happened to that person that mugged that guy. They don't know what's happening. Sure, they can look up a specific case, but you have to go in and trace through. It's just not well known. People know. People don't know what's happening in their courts. And as we have stressed transparency, I mean, this body that we sit on is very transparent in what we do. That we have this glaring, 1/3 of the government of the state really, and it's not intentional, I got it, but just because of the circumstances, they operate largely out of the public's knowledge. Most jurisdictions don't have a court report. In my county years ago had a reporter from the Baltimore Sun who was in the courts all the time. That's gone. That's been gone for years. And I dare say that's probably all the jurisdictions. There's not that newspaper reporter sitting in there to track this stuff down. So we have this need to know. We need to understand what's happening. And to say you can trust the judiciary, well, I like to say you can trust the Senate and all these Open Meetings Act, you can trust us to do the right thing. Just pull these cameras out, let us operate, we can have discussions in sidebars and all that. But that's not the way we work. So, and I know, Mr. Scully, your testimony was that this is not consistent with the Criminal Sentencing Commission policies. But I got schools that are doing policing because they have violent crime in the schools. I have police who are doing social work, mental health work. So we're all being stressed now to go beyond our original statutory intents here to address the violent crime. Currently, when we look at the number, we've also got the problem that the number of parolees and probationers and pretrial release folks that are involved in violent crime continues to increase, and we've had so many cases recently of that. So there's a problem here, and I'm not convinced that every line in this bill is exactly what we need ultimately. But the status quo just is not acceptable because murder is rampant. So Mr. Sully, I must have misunderstood your testimony, or maybe I'm missing something, but I really like to know what it does take to for your commission on criminal sentencing policy to comply with this. I didn't see it in the written testimony. Maybe I missed. I thought you said the details were in there, but I didn't see it. So in order to fulfill the mission is per the statute, what would you need additional?
Well, good afternoon, Senator Castle. It's good to see you again.
Yes, you as well.
So the answer is, and I think you were a member of the Sentencing Commission when we debated this in the past. And so the real key variable in terms of presenting the information that's requested in this legislation is the judge's name. That is not something that is collected by the Sentencing Commission. So that is something that would be need to be amended in order for the Sentencing Commission to be able to provide the judge-specific information that this legislation requires. And that is a policy of the Sentencing Commission to not report by individual judge. That has always been the policy of the commission, as I think you are aware. So that's really what the main requirement or difference here in this legislation is.
But it's my understanding that it's actually reported, but it's reported in code. So we're collecting it. We're just, judge number 372 It might,
Not for the, sorry to interrupt, not for the sentencing guidelines worksheet, Judge, Senator Kessley, no. The guidelines for sentencing guidelines are initiated in the Maryland Automated Guideline System. That's our web-based application, and the judge's name is not information that's reported in there. There is a PDF that can be printed, which is, off of the Maryland Automated Guideline System, and that has a location for the judges to print and sign their name. And that is that is saved in the court files, but that hard copy record is never forwarded to the Sentencing Commission, so we don't have that information to it.
okay, so it's not.
Yeah, I think you're thinking of other court-related files that do have a judge identifier. I believe that's
okay. Thank you on that. I'm somewhat sympathetic to the argument that, put it in simple terms, if I'm late for work one day and you're going to judge my career because I'm late for work one day, that's probably not very fair. That I was 2 hours late yesterday, but if I've been on time for 90% of my time, it's kind of unfair to judge me by that one morning when perhaps I had a sick child and my tire went flat, and et cetera, et cetera. And I know cases are like that where even the most conscientious judge sometimes gets that case where they realize that perhaps there's something with the evidence that could result in an acquittal of a case, and that for someone who we pretty much know is guilty, and the judge would rather, go with a plea deal that allows them to at least get this person on something than nothing. And those tough cases happen, those do happen. But if I have a judge over a 10-year career who's always substantially below the guidelines, isn't that indicative? And shouldn't the public know that? Shouldn't the public know that because certainly defense attorneys know it, whether it's anecdotally but amongst themselves, they know it, and prosecutors know it. The only ones that don't know it are the public. That here is your very soft on sentencing judge. Why should the public not have that? At least that level of information.
Would you like to direct your question toward?
I guess I'll put Judge Wilson on the spot. He's got more knowledge in this stuff. We haven't seen him for a while. He's got legislative experience and he has a great beard. He can kind of bring that out.
Senator,
true.
Thank you, Mr. Chair and Senator Kessley. And I would note, of course, that you within your family have had a great resource of information on the criminal justice system after a lifetime. The two things. One, part of what I hear you talking about really goes along more with the judiciary's case search function, which is separate from the guidelines. Case search in Maryland does not identify a judge by name. It does in some states. Pennsylvania, I think, is one, and that's just a policy position taken by those entities. But it is an easy way to find out what happened to a particular defendant, because today with proliferation of smartphones, you can bring up the case search function, put in the defendant name and county, and have the result of that case within about 30 to 45 seconds. So the outcome can be known. I think there is more information available to the public now than there ever has been before. You're right, though, that the newspapers being somewhat overwhelmed on one hand and also understaffed on another, do not report in the same way that they used to. In Hagerstown, we do have a local paper that does often have a reporter in the courtroom for larger cases, but quite frankly, I know that's a rarity across the state. As far as the guidelines and your question about notification to the public of the basic information about a judge's sentencing practices over a lifetime. Again, I go back to the written response or written position of the commission that without getting into the policy of whether that type of scorecard system should be available, at this point, the Maryland Sentencing Commission is not the vehicle for it. If you go back and look at the original document, the original statutory scheme that was created, the purposes, it is there to teach judges, not to teach the public. And I don't disagree with you that the public should have access to what happens in the courtroom without getting into the whole area of video and cameras and TV in the courtroom. They must always remain open to the public. But the Maryland Sentencing Commission has such a limited role, which is guided towards helping judges to try and understand what criminal sentencing is happening across the state, to put in the function that this bill would do, it would require basically a significant increase in staff, significant increase in funding, and I don't think that it simply sits with what the purpose of the commission was. So again, we're not talking about the policy, but we are talking about the commission. Yeah.
But when I just heard Mr. Sule's testimony, all we're lacking is one more field on the guideline sheet. We add one more field that identifies, every judge has a number, you fill in your number and it goes and the data's there. And then the commission, everything is computerized. So I'm not understanding why that's such a difficult technical hurdle to achieve.
Well, I think it's more than that. You do have to have the field in that would identify particular judges. Then you'd have to process all the information. And again, from your time on the commission, and you served, I think, longer on the commission than I have been on, or maybe about the same time. But the staff worked tirelessly all year to try to put together all of that information and break it down into different fields. At this point, I do not believe that MAGs would have to be overhauled a good bit in order to obtain the individualized score sheets that you're talking about. That's my understanding of how MAGs work. So it's not just a simple checkbox, but also then you have to rewrite the program.
Yeah, well, I'll just conclude, by just again offering to work with the judiciary, because look, since I've been on this committee, crime has grown worse and worse. I'm not taking that as my fault, but the crime has gotten worse and worse over the 7.5 years that I've been on this committee, and we've had a lot of players at the table, but generally the judiciary has not been one of those. And at some point, because you are one of, if not the major player in this system, which is a lot, it's not smelling right, and certainly judiciary needs to have the public needs to see the judiciary is not part of the problem, part of the solution. I really would love to hear from the judiciary standpoint what we can do to make the public feel more confidence that we're not as more pro-lease, pretrial release folks, probationers especially, pretrial release folks especially, are involved in violent crime. I would love to hear some solution being offered by the judiciary, as opposed to, hey, we don't take stance on public policy, we just make public policy. It would be really great to hear you all chime in with some suggestions, because I see this as a problem, and maybe this isn't the best solution, but it's the only one we've got before us right now. And I really feel it's incumbent upon the judiciary to step up here and sit down and be a part of this discussion, because this is a crime crisis. We just changed everybody's constitutional rights, their liberties, because we had a virus. Not taking sides in what was appropriate, not appropriate. People made huge sacrifices to their personal liberties, their livelihoods, simply because, not simply, but because of to combat a virus that I never would have thought would have been appropriate. Shutting down the courts, telling landlords they can't collect. I've got people who haven't collected now for over a year on landlord-tenant debt. We made a lot of inconveniences because of the COVID. Now we got another crisis, and that's crime. And just because we were historically established to do a mission isn't good enough, because landlords are historically, the courts were historically there for the landlords and litigants. And we've made a lot of sacrifices because of COVID. And I'm not saying it wasn't necessary. I'm not debating that one. It's just that when a crisis hits, it's all hands on deck. We got to address this. And I just don't feel that sense of here, we're here. We got our shovels. We're ready to fight the fire with you guys. Let's go. It's not there. And so I would really just, my plea is to the judiciary, come on and sit down with us. Let's talk about this and see what we can do. Because to say there's not a problem when we keep getting news report after news report of pretrial release folks and probationers involved in violent crimes, we just can't, the status quo is no longer acceptable. So, and just to say, well, that's not our historic mission, we're all beyond historic missions right now. So thank you all very much. I appreciate your indulgence, Mr. Chairman.
Excellent. Thank you very much, Senator Kessler. It's a deliberative committee here, but let's get to some questions. All right. Senator West, you're up.
Thank you.
We can hear you.
Okay, thanks. Thank you, Mr. Chairman. It's great to be here with Judge Wilson, who served very happily with me, I hope, in the House of Delegates for 4 years. So I'm trying to get to the bottom of some of the factual questions here. Apparently, every judge completes a sentencing. By the way, I'm a new member of the commission, but I'm really a new member of the commission. So what I know is probably a fraction of what certainly Judge Wilson knows, or even Senator Cassidy. So excuse me if I'm not up to everything. So every judge completes the sentencing guidelines worksheet. And then according to the fiscal note, it says that after the judge or his designee completes the worksheet, the judge reviews the worksheet for completeness and accuracy and submits a copy of the worksheet to the commission. So then I go over to the bill and I see in the bill what the commission should report. And it says for each case involving a crime of violence, the commission should report a lot of information about the case. It sounds to me as if most of this information is on the worksheet. So it's in the possession of the commission right now. Well, the one thing that's not is the name of the sentencing judge or the number of the sentencing judge. So let me just ask a question or two about this. At the moment, if the GOCAPs, for example, wanted to come and review the files of the commission to extract information from these worksheets, would GOCAPs be permitted to come to the commission's offices and sit there and obtain that information?
We'll go to Judge Wilson.
Probably Judge Wilson is best. Or Mr. Soleil, one or the other.
I'll ask that Dr. Soleil be unmuted too. And the answer is the guidelines worksheets are public. Okay, they can be reviewed by the public. I will ask Dr. Soleil to answer where the repository is. Because we do, I do many of these all the time. And then I give them to my law clerk who actually does the filing of them, make sure that mags is filled out. And then they go away into that digital realm that I try to stay away from. So Dr. Soleil, perhaps you can explain where the guideline sheets go after the judge signs off on them.
Right. I think it's probably helpful to think of it pre-mags and post-mags, to be frank, because Senator West, before there was an automated online system, these were all paper worksheets and hard copies were mailed into our office. So to answer your first question, yes, GOCAP or anyone else could come to our office and look at the guidelines worksheets. That absolutely was something that anyone would have had the right to do. The guidelines worksheet is a public document. It was, and it always has been, and it still is today. Now, all the worksheets are done online application. There is nothing mailed into our office. So there is no repository to achieve other than the data that we have. And that data is publicly available, and we routinely provide it to requesters. We would, and including GOCAP, we've provided it to GOCAP, but the distinction is that data does not have the judge's name in it. So that does not exist in the data as it's currently collected.
Okay. And let me just add though, Senator, the worksheet that the judge physically signs off on is scanned. I guess it goes into the court file locally then, but there's not a general repository. Is that correct, Dr. Soleil?
Correct. Not one that comes to the Sentencing Commission, right? It would go into the individual court files. I think you're still on mute, Senator West.
There you go.
So, so if it's all electronic, GOCAPs could simply access the electronic files and in some way program the form in which it wanted to download this information and get the information downloaded. And is that correct? Dr. Soleil?
Yes, I mean, they would have to add information to it to include the judge's name or identifier to get the specific information that's required by this legislation.
Okay, and if GOCAPs could do it, could a newspaper do it, and could just a public spirited citizen using a Freedom Information Act request get access to that information too?
Anyone could get access to the information, yes. It's
okay.
Publicly available.
So all we're lacking, it sounds like, is the name of the judge. Am I right on that? All the rest of this is available.
Yeah, so some of the Correct. I will note that there are statistics that are required, would be calculated. They're not, recorded in the exact manner that it's required by the legislation, but the data is there that could be manipulated to acquire the statistics that are asked for in this legislation.
So all we don't have that this bill is asking for is the name of the judge. And I couldn't understand, Judge Wilson, you indicated when Senator Grassley asked, would it be hard to include the name of the judge on the form, on the sentencing guidelines worksheet, so that it would be captured by your commission? You seem to indicate this would be hard and bureaucratically cumbersome.
I'm sorry, my understanding is it's already on the form, just so you know, the form that the judge fills out, we actually physically sign that. So our signatures on every guidelines worksheet for every case that requires a guidelines worksheet. My understanding, and Dr. Slay again knows this much better than I do, is that in order to modify the program that we use, it's one thing with paper. All we had to do was use a little whiteout, going back in time, and then we could type in the new word or new whatever. With the computer program, it was my understanding that would require significantly more time, money, and whatnot in order to not only capture it, but then also to use it and to develop the data into the form that's being requested by the bill. But again, Dr. Saleh knows the inner workings much better than I do, and I'd certainly rely on his answer.
Yeah, I wouldn't want to pass this bill to impose a terrible burden.
Well, we did
commission, but
in the
it
fiscal and
doesn't sound
operational
like
note,
just adding the judge is going to do that. Go ahead.
Sorry, in the fiscal and operational note that we provided, we did attach that there is programming requirements, and I wouldn't say that those are overly onerous. They are doable. I'm not saying that. What I think our testimony was getting at was that it goes against the policy of the commission to not report by individual judge. So I don't know if I want to make sure we're clear in the distinction there. That's the policy the commission has always had. We also don't report at the individual jurisdiction level for the same reasons, because 7 of the 24 jurisdictions are one judge shops. So that would be tantamount to judge specific information. So the commission has always had the policy to not report at the individual judge level. We don't have the variable to even do that. But it can be done. I'm not saying it's so onerous that it can't be done. I do want to make that clear.
Yeah, thank you for your answers. I really wasn't getting into the policy determination of this issue. I was just getting into logistics, and it doesn't sound to me as if logistically we're talking about a huge insurmountable obstacle in terms of adding the judge's name to the reports. Policy-wise, that's something the committee's going to deliberate. But thank you for your answers to my questions.
Sure. Just real quick, so logistically, you're saying that an enterprising grad student right now could, in theory, go through and find all this information, centralize it, and aggregate it, because it's all publicly available right now. It's just not centralized and aggregated in the fashion and form that we wanted.
And then it would require some effort, because it would require a data file from another entity that would have the judge identifier name in it, which we don't have. So it would require merging the sentencing guidelines data and that other data together.
But the judge would sign on this sentencing when the judge's signature is going to be on that file.
So if an enterprising graduate student could go retrieve individual, from the court files, not from the sentencing commission files, because we don't have a file that has a hard copy file.
Understood. Yeah. But in theory, that information's out in the public, just not centralized and aggregated. Okay. So it's Senator Hedelman, and then we'll go to Vice Chair Wallstrecker.
Thank you, Mr. Chairman. I just want to follow up on Judge Wilson. You said in response to Senator Cassidy's questioning that the commission wasn't the right place. And I guess the question is it not the right place because that wasn't part of the policy mission of the organization? Or are you suggesting that there is, if you're not the right place, what is the right place?
No, I was going back historically at the creation of the commission. It was created to benefit judges, to then benefit the citizenry by having judges understand better what the sentencing policies were across the state, to try and bring into focus disparities based on whether it be race or region in order to, again, level out sentencing so that there is not a huge disparity, even though there would always be some geographic disparities. If the statutory scheme were changed and statutory purpose was changed, then it could certainly be with the purpose of the commission. But as it currently stands, my reading of the founding principles of the statute were not to get into judge specific information, but to get into judge helpful information that we can then use to better identify sentencing or appropriate sentencing in each individual case.
That's helpful. Thank you.
All right, sorry for that. We needed to switch the chair functionality here. Thank you all for your questions. And actually, I had a quick question for Dr. Soule, just following up on the chair's logistical questions. So I'm just trying to understand what's happening technologically. And so I understand that you don't release the judge's signature and that there's no field in MAG for a judge code. But do you have the judge's signature? In other words, if you were forced by law to release that information, is that information you have access to?
No, it's not. So, right, there's the MAGs, which is an online application, and that's where the guidelines are calculated. And then the judges are going in, and the judges and their court staff are going in and submitting it. And that is all submitted electronically to our database. That application doesn't have a field where the judge's name is not collected in that application. What that application does allow for is to print a PDF. So it provides that function. So it creates a PDF, which is a one-page document of the sentencing guidelines worksheet. That document has a space on the bottom right-hand corner that allows for the judge's signature. The judges, after the worksheet has been submitted, will sign the document, and then it is scanned into their court files. That copy is never submitted to the Sentencing Commission. We do not have any paper trail of a hard copy, so I can't provide that document upon request because I don't have it.
Understood. And so just to be clear, the logistical, I understand the policy of the commission, but the logistical barrier of adding a judge code field, that's not necessarily the solution that is required here. In other words, the PDF that the judge signs could be transmitted to the commission, and then the public could have access to that PDF in addition to the electronic worksheet. Is that correct?
I guess that would be a function. If we were then become, yes, operationally have to think about how that would work in terms of us storing the tens of thousands of worksheets that would be received every year. But yeah.
Okay, I'm not trying to make your life
right.
difficult. I was just trying to problem solve a little bit on the fly here. When something is submitted to you electronically, does that carry metadata that is stored somewhere that would somehow, if someone looked into it, reveal the chambers from which the electronic data was sent?
I don't know the answer to that, Vice Chairman Waldstreicher. That's a good question. I'm not a techie, so I don't know that answer. Certainly something that I could look into if the committee would like us to look into that further. The application is hosted for us by the Department of Public Safety and Correctional Services. We are a very small agency. We have a budget of $573,000 for fiscal year 2022, just to put things in perspective. So we are very lucky and fortunate to have partner criminal justice agencies that have helped us out tremendously, and public safety is graciously hosts this application for us because we don't have programmers on staff. We don't have that type of data, assistance within our small agency.
Got it. Thank you for working through this with me. I think I understand the current MAGS world and the options that are perhaps in front of us. In the old world, in the pre-MAGS world, when things were done by hand and submitted to you, those worksheets, did those worksheets then have signatures on them?
They did. We do not data enter the name of the judge into our database. And that was a purposeful decision, to be frank, to be consistent with the Sentencing Commission's policy of not reporting data at the individual judge level. So we did have those hard copy worksheets pre-MAGS, which is, dates 2012 is when we first rolled out MAGS in Montgomery County and then gradually throughout the rest of the state. So there were hard copy paper worksheets at that time.
So as a member of the public,
yes,
if I wanted access to a pre-MAGS worksheet, can I get that from you, or do I have to get that from the court?
So we don't have we do have, I don't know the exact dates off my head, but we have a data and retention policy at some point. The very old worksheets have been archived to state of Maryland's archives. We don't have all those in our possession anymore. We do have, and I don't remember the exact number, a few years before 2012 on file in our office. And I think we're supposed to maintain them for 7 years. So even those ones at 2012 were probably past that kind of 7-year period where we have to maintain the hard copy, but they've all been data entered into the electronic database.
Right.
Not into MAGS. There was an access database that we maintained prior to MAGS, but they've been data entered. But the hard copies, we have some of the ones that are probably close in date from 2012, and as jurisdictions transitioned into MAGS from those years that followed. And according to our data retention policy, they have to be maintained for 7 years.
So the pre-MAGS ones that have been retained have the signature on it, but there is a pre-MAGS database associated with the pre-MAGS forms. And does the pre-MAGS database have judicial information?
It does not.
Okay. And then, so let me just kind of go back in time. So my understanding is that currently, if I wanted a pre-MAGS worksheet, I could access it from you if it had been retained and it would have a judge's signature on it. If we were back then, in other words, if we were pre-MAGS, could I have done that same thing then? In other words, in a pre-MAGS world, had I requested it, would I have similarly received the same worksheet with the judge's signature on it?
Yes, I mean, the guidelines worksheet is a publicly available document. So if you had come to us and requested permission to do so, we would have, allowed you to access our files and pull them and make copies of them pursuant to the Maryland Public Information Act.
So I guess what I'm getting at is it sounds like when MAGS was created, it created a much more sophisticated, efficient, and easy to use tracking of information, but simultaneously a policy decision was made, not by the legislature, not even by the judiciary, but by the commission to remove the names of judges, because in a pre-MAGS world, judges' names were available, and in a post-MAGS world, they are not. That it is essentially a policy decision was made in 2012 to change how we handle those things. Is that a fair statement?
I would disagree slightly with the statement in the fact that we were never recording the judge's name into our pre-MAGS database. So the simplicity with getting the data, which we readily and frequently replied, the electronic database, the judge's name was never in there. So I guess to answer your question, the only way would have been if someone had come and retrieved the physical paper worksheets, copied all of them, brought them back themselves, and created their own database off that from that information. So I don't think that MAGS made it significantly, I don't think it really changed the difficulty level in trying to have that information by judge.
Right. But if someone wanted to do what you describe now, they would be unable to do that outside of MAGS because you no longer have those forms. They would have to go through the judiciary in order to obtain that information, where once they were able to do that through the commission.
Correct.
Okay. All right. I think I understand. Thank you for humoring us as we try to understand the technology and history behind these documents. And thank you to the committee for indulging me for that series of questions. Are there any other questions for our witnesses here today? All right, looking around the Zoom room, seeing no further questions, that concludes the hearing on that bill. Thank you all for that enlightening hearing. Thank you, Judge. We really appreciate your presence here. We'll now move on to Senate Bill 397. Senate Bill 397 is jointly assigned with the Budget and Tax Committee, and we welcome Senator McCray, who is representing the Budget and Tax Committee, and we'll go to Mr. Mitchell for your testimony.
Thank you, Mr. Vice Chairman, Wall-Striker, and members of the committee. Again, for the record, my name is Kiefer Mitchell, Chief Legislative Officer for Governor Hogan, here to present on Senate Bill 397. We're here today on behalf of the governor asking for a favorable report on Senate Bill 397. From day one of his administration, the governor has been focused on building transparent and accountable and effective law enforcement institutions that bolster police morale, community relationships, and public confidence. The unfortunate reality is that law enforcement agencies in Maryland and across the country are struggling to attract and retain qualified officers. To combat this, the governor announced that he would be investing $500 million to increase support for law enforcement and increase crime and victim initiatives across the state. Following the announcement, even the Biden administration agreed that we needed to be increasing law enforcement funding, not decreasing it. On January 24th, President Biden's press secretary stated, and I quote, "Underfunding of some police departments and their need for additional resources, something the president has advocated consistently for the course of his career. That's something we know we need to take action on." And just last week, President Biden again reiterated his plea to increase funding for law enforcement. Additionally, a recent Pew Research study found that 47% of Americans believe that spending on police in their area should be increased. That's up for 31% since June of 2020. With increasing rates of violent crime across the country, it is important that we act now to keep our neighborhoods safe and free of violence. Governor Hogan is committed to providing the financial support and tools necessary to protect our citizens and communities, which is what Senate Bill 397 will accomplish. With that being said, Mr. Vice Chair and members of the committee, I would respectfully request a favorable report. And now I'll turn it over to my colleague, Aaron Chase, who will go over the details of the legislation.
Thank you, Mr. Mitchell. Ms. Chase.
Thank you, Vice Chair Waldstreicher and members of the committee. Again, my name is Aaron Chase with the governor's office. As Kiefer mentioned, Senate Bill 397 makes the governor's 50% increase in SAP funding permanent. Established in the 1980s, this funding is provided annually through the state general fund and is used to provide financial support to our counties and municipalities' law enforcement agencies. SAP funding is a formula-driven program used to supplement resources for police protection in our communities. Funds are distributed based on a formula that factors in population density and the number of residents. The formula has not been updated in over a decade. In fiscal year 2022, our counties are slated to receive over $74 million, and in fiscal 23, that will increase by nearly $50 million for a total of $122.5 million. This additional funding will allow law enforcement agencies to increase salaries and wages to ensure we are attracting and retaining the most qualified individuals, maintain and upgrade vehicles and technology, among the other various allowable expenses granted under current statute. The second part of the bill allows for the creation of the local law enforcement coordinating council and the accompanying coordinator position. We share the common goal of reforming our police to protect civil rights and increase public trust in law enforcement. And the creation of this council is an important tool that will greatly assist our local law enforcement agencies and will ultimately better serve our communities. The council and coordinator will be responsible for developing model policies and procedures to enhance coordination, identify resource sharing opportunities, coordinate training that will allow for uniform implementation of standards and programs, develop, implement, and coordinate professional development, and research best practices. The dedicated exploration of these areas will maximize collaboration and foster better partnerships across the state so that each agency is able to create and maintain a culture of service that builds trust and legitimacy in our communities and provides for the safety and well-being of all Marylanders. Establishing this council will mean that our law enforcement agencies can better collect, track, and share data, for example, to track the implementation of body cameras. As the chiefs and sheriffs may mention, they've been working diligently to implement last session's police reform bills, and this council will enable them to better arrange for training and seminars to ensure that our officers are in compliance with the law. Ultimately, this legislation aims to properly equip our men and women in blue to ensure that they have the tools and resources to effectively do their jobs to keep our neighborhoods and communities safe. For these reasons, we ask for your favorable report on Senate Bill 397.
Thank you, Ms. Chase. Next is Mike Lewis. Sheriff Lewis.
Good afternoon, Mr. Vice Chair, distinguished members of our Senate Judicial Proceedings. I'm Wycomico County Sheriff Mike Lewis and the current president of the Maryland Sheriff's Association. I'm here in support of Senate Bill 397 on behalf of the Maryland Chiefs of Police and the Maryland Sheriff's Association. On behalf of both organizations, I'd like to thank Governor Hogan and his team for introducing this legislation. The increased funding for state police aid is critical to assist our local law enforcement agencies in reducing crime, strengthening community relationships, and building upon public safety initiatives. The Maryland Chiefs and Sheriffs strongly support the creation of a local law enforcement coordination council and coordinator position to provide a forum for local law enforcement to work collaboratively on public safety matters and solutions. The council and coordinator will assist local law enforcement with identifying best practices, developing model policies, sharing data, training the next generation of chiefs and sheriffs, and providing professional education opportunities for senior executive level personnel. These functions are critical as our profession evolves and we begin to implement the many police reform measures enacted last session. The council and coordinator position are modeled after the State's Attorney's Coordination Council, and this formalized structure will fill these needs. I know some of you may be asking yourselves, how will this body be different from the Maryland Police Training Standards Commission and the Law Enforcement Coordinating Council that was created just last year? To that, I would say these entities have a broader focus and do not provide the model policy development or the data collection and training and professional development envisioned by Senate Bill 397. The Maryland Police Training and Standards Commission develops training standards for officers and adopts regulations to implement policy, but it does not address model agency policies or provide the leadership training that we so desperately need in 2022. The Law Enforcement Coordinating Council, with few local law enforcement agency representatives, is about sharing resources and coordinating across state and local agencies, specific to ensuring local law enforcement agencies are building the best agencies they can by implementing these model policies, sharing information, and building senior executive ranks for tomorrow. I hope you will give this legislation serious consideration. At this time, I'd like to turn it over to City of Laurel Chief Russ Hamill and First Vice President of the Maryland Chiefs of Police Association for further comment. Thank you.
Thank you, Sheriff. Chief Hamill, you're up.
Good afternoon, and thank you, Vice Chair Waldstreicher and the honorable members of this committee for allowing me to appear before you today. As Sheriff Lewis said, I'm the first Vice President of the Maryland Chiefs Association, and I'll pick up from where he left off. Often questions arise during policy discussions regarding important topics surrounding model policies, such as use of force, pursuits, and body-worn cameras, or something as simple as which agencies actually have body-worn cameras. This type of information is frequently not known because a single entity doesn't have the responsibility to develop model policies nor collect such data. Also, while the Training Commission establishes law enforcement training requirements, there is no single entity that is responsible to focus on leadership training and professional development at this time. When new legislation is enacted, all law enforcement agencies are expected to be informed and prepared to implement those changes. Yet there's no formalized structure to educate agencies on these changes, and I'll talk about that more in a moment. If this legislation is approved, the coordinator will help ensure that these duties are effectively performed and will coordinate with other law enforcement commissions and councils to do so. It is envisioned that the local law enforcement coordination council will meet throughout the year to discuss appropriate model policies, data collection efforts, and help lead further efforts to enhance leadership training and professional development that is so important for the future of law enforcement in this state. Before closing my comments, I'd like to provide a concrete example of how this structure is envisioned. Following the enactment of the important police reform legislation last session, Chiefs and Sheriffs Association representatives immediately began preparing training sessions to educate the entirety of law enforcement agencies throughout Maryland on the new legislation, the new legal requirements, and the implementation dates, because there was no other entity with the responsibility to do so. This was coordinated with the Training Commission to help ensure there's no overlap. A total of 6 in-depth training sessions were conducted, and frankly, we needed more. Preparing and holding these sessions took extreme time to be able to do so. With additional resources, more training sessions could have been scheduled with smaller groups, or additional trainers could have been trained in this important topic area. As we move forward to implement these new laws, many more training sessions are going to be needed to ensure executive staff across all agencies properly implement these new requirements. This new council and coordinators envisioned to serve as an integral part of this effort and to assist in enhancing professionalism, transparency, and accountability within law enforcement across the state, which, as we all know, we all seek and desire to have in place. I will close by respectfully urging your support for Senate Bill 397, and I sincerely thank you for taking the time to listen to me today. I greatly appreciate it.
Thank you, Chief. We'll next move to DePaul Nibber.
Thank you, Mr. Vice Chair, members of the committee. My name is DePaul Nibber, representing the Maryland Association of Counties in support of SB 397. As you've heard, constant and consistent coordination of information and resources across county lines is needed to ensure the effectiveness of law enforcement. Our counties often need open lines to handle cases regarding everything from sex trafficking to gun running. It is rare that these issues impact one specific geographic area. Regarding funding, in recent years, our counties have worked hard to ensure that they are following best practices regarding everything from review boards to training to body cameras. The major impediment to ensuring success is funding. This bill would play a significant role in aiding our counties as they implement our shared law enforcement priorities. For these reasons, we urge a favorable report of SB 397. Thank you.
Thank you so much, DePaul. Next, we'll hear from Angelica Bailey. Ms. Bailey.
Hi, thank you, Mr. Vice Chair. Good afternoon, committee members. Of course, I'm getting a phone call as soon as I start talking. I'm Angelica Bailey. I'm Director of Government Relations for the Maryland Municipal League. We're here in support of Senate Bill 397. First, we want to thank the governor and his team for this bill. Many of our members report challenges with hiring and retention in their local police departments, and we really think this could help. Operational needs for police departments are often the second biggest chunk of a municipal budget, just behind public works projects. So we really rely heavily on state aid to help us meet a variety of those operational needs. This bill adds almost $1,000 per municipal officer in addition to additional grant funding, and across 90 municipal police departments and their 1,800 officers. That's almost $1.7 million. That can really go a long way to help defray some of our ongoing operational costs that could be spent towards things like protective equipment, evidence processing, professional development, training, and that flexibility is also very much appreciated. The result of all of this could go a long way in helping us attract and keep quality officers. So with that, we thank the governor again and request a favorable report. Thank you for your consideration.
Thank you so much, Ms. Bailey. That concludes the testimony on behalf of Senate Bill 397. We'll now move to the committee for questions. Senator McCray, I see that you have your hand raised if you have a question for anyone here today.
Thank you, Mr. Chair. Just want to say I got a couple questions. And first, I want to start by a comment. I think that, just coordinating with public safety agencies is of the utmost importance. I'm glad to see that the governor is taking the lead of Senator Hayes, who put forward the PROTECT Act back in 2020 in reference to making sure that we could have that collectively working together as respective local and law enforcement agencies. I guess the question is that my first question is that I didn't see like MDTA, MTA, and state agencies. We know that there are a number of state agencies that should be collaboratively working together outside of just the state police. So if you could just deep dive into if they are into this, and if they're not, help me understand why they wouldn't be involved and engaged in this piece of it.
Thanks, Senator. Are you referring to working with city police or just overall?
So it looks like you all are creating this coordinating council. It looks like you all are creating a coordinator who would be the state police and things of that nature. So you've got these folks that are lined and specified who would be on this coordinating council. I believe that MTA, MDTA, it's a number of different state agencies that play a role in reference to public safety, but I didn't see them in there. I just wanted to get clarity whether they are engaged in this piece or body of work that you have at this moment, or if you don't feel as though they should be involved. And if not, just help me understand why.
They're involved. They're just not spelled out into the bill, and I'll let Erin talk a little more detail if she.
Thanks, Kiefer, and thanks, Senator McCray, for that question. So when we put the bill together, we did not include those agencies. I don't think that was intentional per se. So if it's an interest in moving this bill forward and to add those agencies, certainly open to that conversation. As the chiefs and sheriffs mentioned, they want this to be very locally coordinated. I'm not sure if those state police agencies are involved in the state coordinating council or not, but definitely willing to have that conversation with you if you feel they should be included.
Yep, I'll leave it at this. I won't ask any more questions, but I will leave with this last comment. I do think that everybody have to collectively come together. Just as a FYI, like MDTA do patrol like some of the things that lead to some of our major highways, 395, 295, and things of that nature. MTA does make sure that they police the bus stops and things of that nature. So it's not just in Baltimore City, it's Anne Arundel County, the light rail and things of that nature. So I think that as we're bringing together collectively in reference to these public safety agencies, we have to make sure that we're inclusive of all, especially because it's a state bill and we do have other state agencies that's involved in law enforcement. The second piece is, as this moves away from GOCAP, I do know that the Department of Public Safety, there's a number of different grants. So I'm going to deep dive and have an offline to understand how some of these agencies, they used to be involved in the coordinating council, but won't be involved. I'm not going to committee hostage at this moment, but I will reach out to you all's office to understand the thinking on that.
Thank you, Senator McCray. Senator McCray, stick around. Your bill is going to be next. Senator Carter.
Thanks, Mr. Vice Chair. My questions are similar and somewhat to Senator McCray. In looking at the makeup of the council as proposed by the bill, I first want to start by saying I believe law enforcement agencies should communicate and should coordinate. I don't know that we necessarily need legislation for that to happen, because that should be a best practice of public safety. But that being said, Mr. Lewis did address my question, which was going to be, could we not somehow include this or make this a part of or an expansion of what already exists, the Police Training and Standards Commission? I get that this is not all within their scope, but I was thinking in terms of having that one entity in the state that creates uniformity of policy and training and best practices, so that there isn't kind of this fragmented, factioned, different way of doing things, but using that one entity as that clearinghouse. So is that not a it may not be your preference, but is it a possibility that we could do that?
I'm happy to talk to you about that, Senator Carter. I think in terms of the training piece, that the only concern I have would be, in light of the last couple of years and the actions of the General Assembly in terms of legislation regarding police training, I think that ought to be more of a laser focused and not sort of make it an unruly type of coordinating council where it becomes overly bureaucratic. But again, willing to talk to you and hear more of your thoughts about it.
Thank you. And my next question was centered around the makeup of the coordinating council under the proposed bill. Actually, Senator McCray, I thought you were going to bring this up. Senator McCray has been making quite an issue of the lack of coordination and lack of accountability with the parole and probation agencies. And I would think that any coordinated effort should automatically include parole and probation to make sure that they are, that there's communication and that they're coordinated and that everybody knows what everybody else is doing. So I would suggest that would be a natural inclusion in this. And finally, and that should be a no-brainer in my opinion. But the other thing that I'm thinking is that we did pass significant legislation to deal with police accountability, transparency, and oversight. And I do have a concern that limiting this council to strictly law enforcement without having any type of additional input from maybe a citizen organization, maybe the violence interrupters, maybe the law enforcement action partnership, some entity that is coming from the perspective of the citizen, because at the end of the day, we want public safety, but we're creating public safety for the benefit and on behalf of the citizens. And I would think that maybe there should be some additional component where there's some additional input from one of those kinds of organizations. Do you have any opinions about that?
We don't have any opinions on that right now. If there's an amendment, again, we'll look at the amendment and we'll discuss it as we go through the process.
Thank you.
Thank you, Senator Carter. Senator Sidner.
Thank you very much. And glad to see my constituent, Mr. Mitchell.
That's right. I am testifying from the 44th District, Senator. You'd be happy to know.
Absolutely. Look, this question is for Ms. Chase, since I want to ask about, I have two questions about the bill. One, and I think it's on page 2, lines 19 through 21. When it talks about one of the council members, it says the chief of a law enforcement agency from each county selected by the chiefs of the law enforcement agencies in that county. And I'm trying to make certain that I understand what that's saying. So, for example, in Baltimore County, I can speak about Baltimore County, Baltimore City, we have sheriffs, but we also have chiefs of police. Is this saying that the sheriff, is the sheriff selecting who the chief? I mean, can you explain what is this going, what the language is trying to do?
Sure. So I think you'll see above in line 18, the sheriff is included on the council. But I think since some jurisdictions do have a number of police chiefs, they would all kind of collaborate to determine who from that jurisdiction, being the jurisdiction being the county, who they would like to be the chief representing the county for all the chief organizations in there. But I may leave it to the chiefs and sheriffs to clarify that if my answer is not clear enough.
So for some jurisdiction like Prince George's County that has a lot of municipalities, but they all have to kind of figure out who they want to be their one representative. I mean, we're talking about, I guess and looking at this, I'm trying to figure out how many people are encompassed in number 3.
I don't have that information off the top of my head, but I'm certainly happy to get that information for you and get back to you.
Okay, thank you. The other question I had on page 6, line 27 and 28, it says that the Council Executive Committee will be able to accept and expend funds, grants, and gifts and accept services from public or private sources. Generally, I mean, looks innocuous, like, I mean, the language looks fine, but in Baltimore City, we have had this experience when our police department used a charity and went ahead and created some sort of a spy plane program. And I'm wondering if when we're talking about the acceptance of these grants and gifts, to what purposes are we talking about? Is it just to ensure that there's funding for this agency to go on? Or are we talking about ways where this particular committee can purchase equipment and then act as some sort of conduit to local police departments? What are you all talking about?
Thank you, Senator, for that question. So this language came, I think, straight from the statute that the Maryland State's Attorneys Coordination Council has. So I don't think we thought too much of it, just thought that since it was in that statute, it might apply here as well. But if there are concerns, happy to have conversations with you about how we can clarify that and alleviate those concerns.
But yes. See, I guess in my mind, as state's attorneys, they're not out purchasing things that the public then later finds out that they have, and then scratching our heads wondering where did that surveillance equipment come from and who gave such authority and the like. So that would be my concern about that language there. I believe that that's all that I have for right now. Thank you.
Go ahead, Mr. Chairman.
All right, thanks. All right, appreciate it. Are we done? We're on the Q&A section now. Is that right?
That's correct. And it looks like we have no more questions.
Excellent. All right. Well, that was the last administration bill. Is that right?
Yes.
All right. Excellent. So that was that Senate Bill 397?
Yes. So we're going to move to Senate Bill 277 next.
Great. All right. Well, that'll conclude the hearing for Senate Bill 397, and then we'll move on to Senator McCray with Senate Bill 277. Senator McCray, welcome.
Thank you, Mr. Chair. Thank you, Mr. Vice Chair, and thank you, members of JPR. Just for the record, Corey McCray, Senator for the 45th Legislative District, come to you in reference to Senate Bill 277. Senate Bill 277, the Maryland Longitudinal Data System Center Division of Corrections Data 3 requirement. This pretty much just tries to put Department of Public Safety in alignment with the other agencies like DJS and things of that nature that kind of give us that longitudinal data, be able to look at some of the correction courses that we will be able to do from a state level to make sure that we operate efficient and effective from that standpoint. So it's more of a transparency, more of an access to information to be able to understand the graduation rate and things of that nature that maybe we need to supplement for folks that are within our penal system, and especially as they're coming out at that moment in time. I'd like to lift up Senator Hedelman, who I also know is working on this respective issue, Mr. Chair, and I think that is simply pretty much explained. I did see that Safety had submitted a letter of information, but I also wanted to recognize that we'll get with them, myself, the House sponsor, to see if we can work out some form of differences, Mr. Chair.
Excellent. Thank you very much, Senator McCray. We'll now move on to your panel, and we'll start off with Ms. Smith.
Ooh, she's not here.
Okay, got it. And then we'll see Ms. Hilliard is here, so we'll go with Ms. Hilliard. There you go.
Okay, thank you. Good afternoon, Chair, members of the committee. Elizabeth Hilliard with the Maryland Office of the Public Defender. The Office of the Public Defender would first like to applaud Senator McCray's efforts to try to make DPSCS and other, carceral institutions fall in line and more transparent. We certainly agree that it is critical to have more information about what is going on in facilities and also what is effective, what is rehabilitative, what is preventive, what are the things that we can and should be doing, what's working, what's not. We are currently working with Amanda Owens from ABLE Foundation and someone from the, I always get the acronym wrong, but the Maryland Longitudinal Data Services Commission to try to improve the language and address some of the concerns we have. We are looking to try to sort of finesse the privacy implications and also ensure that the data that is being requested is inclusive, expansive, and will ensure that we're getting the right information to make the right decisions in the future. So with that, we just urge a favorable report, but with the amendments that we're currently working on to sort of improve and effectuate the real intent of the bill. Thank you.
Excellent. Thank you very much. All right, next we'll go to Ms. Hanson Mundell.
Good afternoon, Nicole Hanson Mundell, Executive Director of Out for Justice. As many of you know, an org that represents those individuals impacted. I wish the senator hadn't come off of his face Zoom, because this is the organization that flagged this bill for the Office of Public Defender to get behind and support and figure out how we could, effectively, one, record the data that is needed, but also address some of the concerns that the impacted community had around the kind of data collected, because surely we want to make sure that the department is collecting the necessary data. This committee almost begs the department to give the necessary data year after year, and they fail to, right? And so with this policy, we would begin to see some ways in which we can support the reentry community. But some of the suggested amendments you all will see that came directly from Out for Justice would be determine the research questions through like a participatory process, right? Prior to collecting any data, secure approval from the multiple directly impacted community leaders surrounding the research questions and data that's collected. We had been approached by Amanda Owens at the ABLE Foundation earlier last year to collaborate on some data around recidivism and the like. And so I think this bill kind of really looks like some of the things that we talked to them about early last year. When we talk about some of the costs of incarceration per inmate, really it needs to be broken down into by numbers, how much money was spent on different supports and basic needs, administration. Much money may be spent, but it is really like unclear how much monies were spent. We want to see more about possession of the state issued photo ID. There was a senator last year who introduced a bill that required the Department of Corrections to institute IDs for our impacted citizens working with Social Security Administration and getting their birth certificates. We haven't seen any movement on that. And so this bill will kind of support and push that. And lastly, Mr. Senator, we want to see individuals may be given minimum useful prison IDs that is technically used by the state, but this is far less useful than being provided like actual ID. So there's a host of concerns we have, but we do support it, right? Because what it looks like is that this reentry committee started to think about how they can work together to get data from the department. And with those being said, we support with amendments. Thank you, Mr. Speaker.
Thank you very much.
Chair.
All right, excellent. Thank you. All right. Now we'll switch over to the informational panel, and we'll start off with Ms. Baskett. There you are. Welcome.
Thank you. Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the Judicial Proceedings Committee. My name is Dr. Jennifer Baskett. I'm the Director of the Office of Government and Legislative Affairs. And with me today is Ms. Angelina Guarino, Director of the Office of Data Development, and Mr. Stuart Nathan, Assistant Attorney General, who is here to answer questions. I'm here today to provide testimony on Senate Bill 277, the Maryland Longitudinal Data System Center Division of Correction Data Requirement. The department's Division of Correction operates 13 state correctional facilities that house offenders sentenced to incarceration for 18 months and longer. Senate Bill 277 proposes the Division of Correction provide correctional services data to the center. The proposed definition of correctional services data is broad and refers to arrest and incarceration data. The Division of Correction does not have arrest data. Additionally, the proposed definition includes criminal history record information, and the department is prohibited from sharing this information by both state and federal law. The bill includes existing language that established the center as a central repository. Correctional services data is not student or workforce data, and the Federal Bureau of Investigation does not allow the creation of many repositories of criminal history record information. The Department of Labor provides educational services for incarcerated individuals participating in GED programs. Therefore, educational data should be provided by the center should be provided to the center by Labor and the Maryland State Department of Education. This could be accomplished by simply entering into a data user agreement without legislation. We are happy to continue working with the bill sponsor, the MLDSC, and ABLE. And with that, I will turn it over to Executive Director Guarino.
Excellent. Thank you very much. All right, next we'll hear from another informational panelist. Angelina, there you are. Scorino, welcome. Let's see if I can unmute you here. Try one more time. There you go.
Good afternoon, Chair Smith, Vice Chair Waldstreicher, and members of the committee. My name is Angelina Guarino, and I'm the Executive Director of the Department's Office of Data Development. The department utilizes an offender case management system, OCMS, that is an integrated case management database that compiles information about an incarcerated individual throughout their time in state custody. It does not and cannot serve as the internal repository for an inmate's medical treatment information. Senate Bill 277 would require a large-scale replication of the data that's currently maintained in the OCMS, as well as other data points that are beyond the department's collection. Continually culling that volume of data requested from OCMS alone would be incredibly labor-intensive and redundant for both DPSCS and MLDSC. On an annual basis, the department can currently generate and provide a report with MLDSC that contains a breakdown of individuals released from the Division of Correction within a given time frame to include their age, gender, race, offense type, sentence length, and type of release. It can also include MLDS provided information in its existing recidivism reports. The department is not able to share personal identifying information in bulk, such as name and date of birth, as this is a component of the criminal history record information that cannot be maintained in a database by a non-law enforcement entity. It also cannot authorize the release of patient data without patient consent to be commingled in a database outside of the provision of healthcare to its inmates, in violation of both HIPAA and 42 CFR Part 2. We would also note that the correctional services data that's being requested would be incomplete, as our data only includes individuals sentenced for 18 months or longer. Individuals with shorter sentences are housed in county-run correctional facilities. They represent a significant proportion of state legal justice involvement, which impacts the accurate measurement of local outcomes. The department understands MLDSC's mission of providing accurate student performance and workforce data, and we will work with them to provide data on incarcerated individuals that can be shared in a more limited, usable, and sustainable manner. In closing, this partnership could already be accomplished without legislation through our existing research process simply by entering into a data use agreement, as the department has already done with independent researchers and other state agencies looking to evaluate long-term outcomes, such as the Maryland Department of Health and the Administrative Office of the Courts. With that, I thank you, and I'm happy to take any questions you may have.
Excellent. Thank you very much. Next, we will hear from Mr. Nathan. Mr. Nathan here. Stuart Nathan. There you are.
Mr. Chair, Mr. Vice Chair, members of the committee, my name is Stuart Nathan, Principal Counsel and Assistant Attorney General for the department. I'm available to answer questions. Some of the legal restrictions have already been mentioned. We do not want to run afoul of any of the state or federal statutory requirements or regulatory requirements for disseminating information. Typically, this type of project would involve a data sharing agreement. We have many of those already in place with various research entities. And I believe that some of those, that type of initiative is already being discussed with the bill sponsors. Thank you.
Excellent. Thank you very much, Mr. Nathan. And with that, that'll conclude the testimony for Senate Bill 277. We'll now switch over to the committee for questions. Seeing none, that'll conclude the hearing for Senate Bill 277. Thank you, Senator McCray. Next up is Senate Bill 319, Senator McCray. Welcome back.
Glad to be here, Mr. Chair. Today I come to you, for the record, Corey McRae, Senator for the 45th Legislative District, and I'm here on a bill that you all heard last year, but this time it looks like it's no opposition to the bill as I went through the submission panel, like the written testimony from that standpoint. But this just makes sure that collectively we're working together to kind of ensure that our swimming pools and the safety of our swimming pools are all across the state of Maryland, not just individually and just different local jurisdictions. I'm joined by a panel of folks, Richard Anderson, Jacob Carson, and Jason Davidson, who are the subject matter experts, but just a person that works in the crafts, a person that works in the trades. This just makes sense to make sure that we're all moving in one direction versus just individually having random things out there. So thank you, Mr. Chair, for the opportunity, and most importantly, hoping for a favorable report for Senate Bill 319.
Excellent. Thank you, Senator McRae. All right, we'll switch over to your panel. And first up, we'll have Mr. Davidson. Welcome.
Hi, thank you, Mr. Chairman, Mr. Vice Chairman, members of the committee. It's good to be back here again. For the record, I'm Jason Davidson, Director of Government Relations to the Pool and Hot Tub Alliance, known as PHTA. We represent more than 3,500 business entities in the industry. We sincerely thank Senator McRae for bringing back this very important bill. As the Senator mentioned, this came before you last year, and the cross-file passed out of the House of Delegates, and it just ran out of time for it to cross over to the Senate. According to a 2015 MDH report, drowning was the second leading cause of death for children aged 0 to 4, and third leading cause of death for children aged 5 to 14. Some Maryland counties have already adopted this code. Other Maryland counties and municipalities are currently practicing parts of this code already, having adopted it through the International Residential Code or as International Building Code. So it just makes total sense to adopt this code as a baseline standard statewide, where local authorities remain the enforcing authority and can amend it as needed, just like all the other codes that we adopt. And this, just like those other codes, were written in accordance with the Maryland Building Performance Standards, which is how many of the statewide codes operate as well. You should see in your packet a letter of support from the Maryland Chamber of Commerce. This business community strongly supports the legislation. And just to be clear, this code only applies to new construction, new design for existing pools. Operation and maintenance will remain covered by the Department of Health. And as the chair, Senator McRae mentioned, there's no opposition testimony. We worked really hard with some of the opposing members to satisfy their concerns. So again, in conclusion, we strongly urge a favorable report, and I'm happy to take any questions at this time.
Excellent. Thank you very much, Mr. Davidson. And I thank you for meeting with me over the interim. I thought our meeting was most instructive, so appreciate that. All right, we'll go on to Mr. Anderson. You're up next. Where is Mr. Anderson?
Oh, I'm sorry. He had to jump over to subcommittee. Our cross-file is in subcommittee. So
got it. All right. Then we'll move on to Mr. Carson. You're here. I saw that. Let's see. There you are.
Thank you, Chair, and members of the committee for having us here today. My name is Jacob Carson. I'm the International Code Council Government Relations Representative for the state of Maryland. The International Code Council is a nonprofit association that develops model codes, including the International Swimming Pool and Spa Code. All our codes ensure user safety in the built environment while also ensuring uniformity and consistency for builders. These are the two aspects, safety and consistency, are what I want to focus on here today. On the safety side, the Swimming Pool and Spa Code is based on scientifically proven best practices to prevent drowning, protection against entrapment, and it ensures compliance with the Virginia Graham-Baker Act. To this end, this piece of legislation is sponsored by the Maryland Building Officials Association and the Maryland Metro Fire Marshal Committee. On the uniformity and consistency side, the ISPSC is coordinated with the International Building Code, the International Residential Code, and the other I codes adopted by Maryland. Its adoption provides consistency to builders who operate between counties or operate between states. For example, this code is adopted by Washington, D.C., Pennsylvania, Virginia, West Virginia, and New Jersey. Subsequently, passage of this bill would create a large unified adoption area that would allow for designers and contractors to work under a harmonized code when working on swimming pools and spas. Because of this, as my colleague Jason mentioned, it's not surprising that this legislation is supported by the business community. It's a great sign of how much of a win-win this bill is, that it's supported by both regulators and by business. Thank you all for your time. I'm here to answer any questions, and the International Code Council urges the swift passage of Senate Bill 319.
Thank you very much. All right, next we'll go on to Mr. Korn.
Thank you, Mr. Chairman. My name is Alan Korn. I'm the General Counsel for the National Drowning Prevention Alliance. I also represent several families that have had children die of water-related incidences, entrapments, drownings, and other water safety issues. I don't represent them in their court cases. I represent them in their public policy efforts and their foundations. There is lots and lots of good things in this particular code. Some of them, address fencing requirements, layers of protection, pool and spa covers, electrical safety, the character and quality of the products that are used for a safety purpose around the pool, and even the water quality and health of pools and spas in the state of Maryland. I'm just going to talk about one particular aspect of the code that we think is particularly important. First, by way of history, and I promise to do this quick. About 12 years ago, Congress and President Bush signed the Virginia Graham-Baker Pool and Spa Safety Act, which requires safety devices on public pools to prevent entrapment. The bill is named after Secretary of State James Baker's granddaughter, who died by a horrific entrapment. I don't know if not everybody might be old enough to remember Secretary of State James Baker, but I sure do. That piece of legislation, like I said, only applies to public pools. The adoption of the code will go a long way towards closing the gap between public pools and residential pools, at least in part. The code applies, as Jason mentioned, to new pools, only new pools, or substantially remodeled pools. So we're closing that gap and requiring the safety device at least going forward to prevent entrapments. And I'll conclude by this, Mr. Chairman, by saying that since the passage of the Virginia Graham-Baker Pool and Spa Safety Act, there has not been not one entrapment in the entire country, let alone the state of Maryland. So these are some devices that the code promotes that are effective and have been proven to be effective. So thank you very much, and certainly I'll answer any questions.
Excellent. Thank you, Mr. Korn. And most of us know James Baker as the prime example of a great chief of staff, also Secretary of State, but awesome, good stuff. All right. That then I think concludes, actually, we have one more witness, Mr. Walker.
I don't see him here.
Okay. With that, then that'll conclude the testimony from Senate Bill 319. We'll now switch over to the committee for questions. Seeing none, that'll conclude the hearing for Senate Bill 319. Thank you, Senator McCray, to the panelists. All right. So are we ready to move on to Senator Reedy?
Senator Jackson is here for his bill.
Okay, great. We'll go back up to Senator Jackson. Senator Jackson, welcome. You were a member here. I just thought you were here as part of, hearings. So good to see you again. All right, we'll go with Senator Jackson, Senate Bill 389. You're up. Welcome back.
Thank you, sir. And thank you, Mr. Chairman. And I appreciate that. It hasn't been that long. I feel like I'm still there sometime. Mr. Chairman, members of the Judicial Proceedings Committee, for the record, Senator Michael Jackson, District 27, on behalf of Senate Bill 385, the public safety article. This committee heard the bill last year. I believe it may have, we had a hearing. I'm not sure whether it passed out or not, but we're at the end of the session. Senate Bill 389 is a piece of legislation that makes a few updates and modifies requirements and terminology for the Maryland Police Training and Standards Commission, commonly known as the public safety article relating to membership, procedures, and training for police officers, law enforcement officers. Among other things, the bill also requires a Training and Standards Commission to conduct job test analysis for entry-level police officers every 10 years or so. These updates are reflective of the work that the General Assembly has done on criminal justice reform since 2016, and many of us on this committee and have worked diligently and continue to do work toward criminal justice reform, as seen with the multiple bills that we have regarding justice reinvestment, juvenile justice reform, and obviously police reform. I'd ask the committee to take a look at the not only the bill itself, but also the fiscal and policy note. Under the analysis tab, you'll find an enumerated list of the work that has been done by the Training and Standards Commission, as well as the inclusion of a number of specialized criminal trainings, i.e. rape or other sexual assault and human trafficking, hate crimes, and other victim services, victim crime trainings. Look, as a career law enforcement officer, training is of the utmost importance, but it's not only in law enforcement and public safety, it's in sports, it's in any business or any entity that you endeavor. You perform how you're trained. And if your training is where it needs to be, then your performance will be at its best. However, there's also, in addition to that, it's also imperative for us to have in place some parameters at which we're seeking to reach in our service. And we need entities that are out there that will make sure that if we're not meeting the goals to provide the service necessary to our constituents, that we can be pointed in the right direction. The Maryland Police Training and Standards Commission has been set up to do just that. Mr. Chairman, I'd ask for a favorable report, a favorable vote on this bill. And I believe we have a panel assembled, and I will stand for questions along with them after they testify. Thank you.
Excellent. Thank you, Senator Jackson. And Sandy, do we have Senator Jackson's panel?
I don't have any witnesses signed up on this one.
No, Mr. Liebno or Sheriff Barry?
No.
Okay. Well, I'll stand for questions if necessary. If you.
All right. Looking to the committee for questions. Seeing none. Appreciate it. Thank you very much, Senator Jackson. We'll follow up with you with the witnesses.
Yes, thank you very much, Mr. Chairman.
Excellent. Thank you. All right. With that, that'll conclude the hearing for Senate Bill 389, and we'll now move on. I see that Senator Reedy is here. So Senate Bill 327. Senator Reedy, welcome back. You know you missed us.
Thank you, Mr. Chairman. As always, glad to be back in the Judicial Proceedings Committee with a bill that I think is very timely, and it's ready for prime time. Absolutely. And I'm excited to present Senator Reedy for the record. Mr. Chairman, members of the Judicial Proceedings Committee, Senate Bill 327 specifies that personal protection or self-defense constitutes a good and substantial reason for the issuance of a permit to carry, wear, and transport a firearm in the state of Maryland. This is the shall issue bill. For those watching and those maybe on the committee that don't know, Maryland, we are a state that currently, as folks seek to exercise their constitutional right to keep and bear arms and to defend themselves, the state forces people to try to justify why they need that protection or why they need a concealed carry permit, instead of what ought to be the burden being on the state to illustrate why someone should not be allowed to have one. The state has an extensive background check, training, and live fire requirement to obtain a concealed carry permit. And this bill doesn't seek to change that, simply seeks to invert it so that the state needs to show why someone should not be able to have a concealed carry permit. It protects the fundamental right of Marylanders to keep and bear arms for personal protection. You know, in DC versus Heller, the Supreme Court held that citizens have the right to possess handguns for self-defense, and this protection should apply inside and outside of the home. In Wren versus DC, the U.S. Circuit Court of Appeals ruled that the District of Columbia's good reason requirement for carry permit was unconstitutional. This bill would make Maryland a shall issue state. 42 states are shall issue jurisdictions. 14 states actually have gone, and it may be higher than that now, maybe up to 15 now, have gone to a total constitutional carry where there's no permitting requirement. We're talking about simply making sure that the state has a law that is fair to all law-abiding citizens who are not otherwise prohibited from having firearms. Maryland has the third most restrictive firearm laws in the country, based on some just looking at the comprehensive overlaying laws. New Jersey, Hawaii have more restrictive laws. California and New York have very restrictive laws, but they allow county sheriffs to determine if a person has a good and substantial reason. So a lot of those counties are shall issue in practice. Maryland's extremely restrictive firearm laws. We started moving further and further towards more restrictions on firearms for law-abiding citizens. We were always pretty restricted, but in 2013, the General Assembly passed then Governor O'Malley's gun legislation to further restrict and add more restrictions on possessing firearms, ammunition, and other clips and other kinds of things. Since 2013, we've passed several pieces of legislation that continue to add more and more restrictions on law-abiding citizens being able to possess, transfer, carry firearms. And we have not seen a corresponding rise in public safety. I think anybody on this committee would agree that we are currently, specifically particular regions of our state, but really all over the state, not safer. And while correlation is not causation, the fact of the matter is, as I look at what's going on in the discussion about crime today, the focus still seems to be what else can we do to further restrict possession of firearms or certain types of firearms for law-abiding citizens, because we know that people who break the law and are violating the law, stealing guns or illegally obtaining guns when they're forbidden to have them, they're not following the law anyway. So this is actually, to me, a common sense step that we should take. And there's litigation that's pending. It looks like the Supreme Court is going to take up a New York case. It's time to give people the opportunity, if they want to have a concealed carry permit, unless there's a reason like criminal record or some other types of disqualifying things you would find in background check. They should be able to have a concealed carry permit to defend themselves and their family. I believe, quite candidly, it would help in some areas of our state if you had well-trained, checked people being able to carry. Criminals do not like it when their victims can shoot back. And it's not even so much about shooting back as it's saying there's a threat that if I'm coming up on somebody, they may be carrying a trained person carrying a firearm that has a concealed carry permit. I would challenge us in this committee and challenge us as a body to say, let's restore these rights to Marylanders, and let's look and see how it develops and what happens. There's many examples of places where when the laws were changed, they saw drops in crime. We've seen our murder rate rise since 2014. We've seen a number of other criminal indicators they're very frustrating and discouraging. So this is the time. And the last thing I'll say about this bill, I know this bill's been before us a lot, and it's a discussion that I think needs to continue to be had. But it's really when you empower people, when you empower law-abiding citizens to have full responsibility and full control of their lives and to exercise their rights, you create more people who are looking for opportunities to serve, to be protectors in their community, and to be helpful. And I think I can't think of a better thing that we could do at an individual level than to empower law-abiding citizens, law-abiding Marylanders to be able to carry if they so choose. Opponents of this bill have often portrayed it as sort of trying to create some sort of wild, wild west. Again, the state has a very comprehensive way that they look at, that they require background checks, training, and other things that make sure that someone has to know what they're doing to get a concealed carry permit. So I think this is a common sense step that we can take right now. And so I would ask for support for Senate Bill 327 to protect and expand on the Second Amendment rights of Marylanders while helping public safety. So I respectfully ask that you give it a favorable report. Happy to take any questions, Mr. Chairman. And I do have, I think, a panel here with some folks who would like to share their thoughts as well.
Excellent. Thank you, Senator Reedy. And we'll do this. We'll take questions at the end of the panel. We'll start with Mr. Pennick. So here, Mr. Pennick, you're up. Welcome.
Thank you, Mr. Chairman. Mark Pennock, President of Maryland Shall Issue. You have before you my written testimony, and it addresses the state of the law and as well the situation in Baltimore as revealed by the 2020 Johns Hopkins study of law enforcement on carry and crime in Baltimore. I wanted to briefly address the reality, the legal reality, and that is Maryland will be shall issue whether this bill passes or not. The Supreme Court is considering the Buren case. It was argued November 3. It involves the constitutionality under the Second Amendment of New York's good cause requirements for the issuance of a carry permit. That was argued November 3, and uniformly, all the observers, and I've been practicing from the Supreme Court for 45 years, it's pretty clear that that requirement will not survive. Maryland's good and substantial reason requirement is indistinguishable from that. Maryland's requirement will fall as well. Currently pending in the Fourth Circuit is a case that Maryland Shall Issue is a party to. That's the Call case. It's referenced in my written testimony. That case is being held by the Fourth Circuit pending a decision in Buren. If Buren is decided the way we think it will be, there will be a remand in that case for an issuance of an injunction enjoining the enforcement of the good and substantial reason. This is an opportunity for the committee to get ahead of that result and save the state a fair sum of money in attorney's fees. Right now, under the Supreme Court's ruling in case law under attorney's fees, there has been no award for attorney's fees in this case possible because we haven't had a judicial decision. This legislation will likely moot Call and obviate the need for the state to pay many hundreds of thousands of dollars in fees. And it's a good idea because you might as well recognize the inevitable here. Maryland shall issue, and it will probably be shall issue by the summer. I urge a favorable report and be happy to answer any questions.
Thanks, Mr. Pennock. When is that decision was argued November? When we expect a decision? February?
That's always hazardous because it's a big case.
Yeah.
Big cases are typically decided at the end of the term and by June, but certainly by June. So you probably won't get a decision before the legislature adjourns in April.
Thank you. All right, thank you for your testimony. We'll now move on to Ms. Novotny.
Good afternoon. Thank you, Chair and members of the committee. I'm Katie Novotny, coming to you from District 35, and I strongly support this bill. As Mark mentioned, we have the Bruin case that we expect a decision on, and that's certainly going to make this state shall issue. And I have a right to self-defense in my home. That's established. Heller established that. But currently in the state of Maryland, as an ordinary citizen, I have zero right to self-defense outside the home. I have no way to defend myself. We see testimony in this committee year after year after year about the rising violence, yet there's not a single thing I can do to protect myself except avoid these dangerous areas. And, we see what effect that's had on the economy of some of these places that are plagued with violent crime. People that do not currently have the right to defend themselves just stay out of these areas. And that's not good for anybody. I'd love to go, down to the Inner Harbor and, the Science Center and the aquarium, but, my husband and I just don't feel safe. We are ordinary citizens that, this body has chosen to deny us the right to defend ourselves. If we carried large sums of money, be okay, you're good to go, you can defend that. But then the funny thing is state law says you cannot defend things. You can only defend yourself, yet we'll only issue permits based on things. And I think that's just not acceptable. So for all these reasons, I request a favorable report, and thank you, Senator Reedy, for bringing this bill.
Thank you very much. All right, next we'll hear from Mr. Ditello. See if we can get you unmuted here. There you go.
Can you hear me?
We can, yes. Welcome.
Thank you. I just wanted to start and say thank you for your time. I just wanted to address here. So I'm an independent voter. civil rights enthusiast, a student. I support limiting police power, decriminalizing victimless crimes, protection of minority groups, including my LGBT family, who I protect with a gun. A core belief of mine is removing these unnecessary rules that limit civil rights and equal rights. What we're seeing right now with the HQL and the carry permits is they have compared to many other states, a very high number of requirements. With HQL alone, it's training, fingerprints, fees. Carry permit, it's again training, fingerprints, fees, photographs, the whole shebang. But a lot of people don't even bother applying because they know that their application, they can hear it hitting the trash when they put self-defense down. When we look at the Second Amendment, I think that's kind of where I come from. Is I want to be able to defend myself. I have no malicious intent with wanting a carry permit. I think what ends up with the current law happening is it targets people who are particularly vulnerable, minorities, those who are less privileged. My wife in particular, who identifies as LGBT, they travel to parts of the state where violent crime takes place, and the current law, it disenfranchises them. It discourages them to exercise their rights. They know that self-defense will be thrown in the trash. But more importantly, I think this is, so in 2021, we had more people buying guns than ever. And, it wasn't just, Republicans or libertarians or independents. It's also Democrats. This is an opportunity to provide for your constituents who could apply and actually get a carry permit. I think that we'll definitely get a lot out of adding self-defense as a legitimate reason for the less privileged or well-off. I urge you to vote favorably on Senate Bill 327.
Excellent. Thank you very much. Next, we'll move on to Mr. Jocelyn. Get you unmuted here. There you go. Welcome.
Thank you, Mr. Chairman. John Jocelyn speaking on behalf of 2A Maryland in support of Senate Bill 327. By adding personal protection and self-defense, Senate Bill 327 clarifies and better defines the term good and substantial, which has been for political football for almost 50 years. It will more closely align Maryland statute with existing case law, and it will recognize that law-abiding citizens have the right and the means to defend themselves and their loved ones. Criminals already carry outside the law. We know this. We simply ask that this bill be given a favorable report so that law-abiding citizens can carry within the law for lawful purposes. That concludes my formal testimony. I'm happy for questions. Thank you.
Excellent. Thank you very much. All right. With that, I think that concludes the panel and the testimony for Senate Bill 327. We'll now move on to the committee for questions. And I know that Senator Sidnor was first, then we have Senator West. So Senator Sidnor, you're up.
Thank you. Before I ask the question, in either Maryland shall issue or 2A Maryland, one of you two may be able to answer this, but I'm curious, are you all, you can just show me by just kind of raising your hand. All right, are either of your organizations connected to a national organization? Or are you just solely a Maryland entity?
2A Maryland is independent.
Independent. And any affiliation with the NRA?
Other than being an NRA member, no.
Could you, if you don't know the answer to this, that's fine. But do you, by any chance, know whether the NRA or any national gun rights organization has put out or issued any type of statement with regards to the killing of Amir Locke?
I'm not sure what that has to do with this legislation, but I would direct you to DJ Spiker, who is the Maryland director for NRA.
What it has to do with this legislation, and I could get to that. That's why I was asking you if you had heard anything.
No, I have not.
Senator, do you want Senator Reedy to chime in?
Please, yes.
I saw that a statement had been put out about the Amir Locke shooting, but I have not seen it, nor do I know its contents. I was aware that a statement was put out, and I don't know exactly what your larger point is. I'm guessing you are right to point out that there needs to be, in the Second Amendment community, we want to be sure that we are protecting the rights of all our citizens. And whenever that is infringed upon or someone is mistreated because they're exercising that right, whether it happens to be government, police, or anything, I think we want to all be consistent on that issue. I do believe a statement was put out, but I honestly haven't seen what was in it.
Senator, Mr. Ditello is raising his hand, but if you'd like to hear from him, that's your prerogative. But
no, and
yes,
I mean, I appreciate Mr. Ditello's testimony, which kind of made me think about this, because it's saying personal protection and self-defense, and I'm just wondering just how that works for somebody that looks like me. If you're exercising of your self-defense rights, or you're actually inside your home and you're shot and killed in the place where, and you've done all the steps that you're supposed to. I mean, I could imagine if I had a license to carry, and I might be shot before you would be shot with your license to carry. So that's what it has to do with, Mr. Jocelyn. And I appreciate your comments, Senator. Thank you.
excellent. All right, Senator. Thank you, Senator Sidnor. All squared away? Okay, great. All right, so we'll go on to Senator West.
There we go. Can everybody hear me? So my question, I guess, is for Mr. Pennick. Mr. Pennick, if this bill should pass, is it not the case that organizations could still ban guns in their premises? For example, the state of Maryland could ban guns in the State House. The people who run M&T Bank Stadium could ban guns in Ravens games. The Baltimore Symphony could ban guns in Meyerhoff Hall. Restaurants could ban guns. Religious institutions of a mind to do it could ban guns in their churches. That's the case, isn't it?
That's absolutely correct, Senator. It has nothing to do with the exercise of power of private organizations or public organizations to ban possession of firearms on their premises.
Great, thank you. That's my question. Appreciate it.
So thank you, Senator West. All right, looking for additional questions from the committee. Seeing none, that will conclude the hearing for Senate Bill 327. Thank you, Senator Reedy, and to your panelists. All right, thanks. Excellent. So now we'll move on to Senator Lee. Senator Lee, are you ready? Senator Lee will present Senate Bill 382.
I'm always ready, waiting and ready. Okay. Okay. Thank you, Mr. Chairman, and esteemed members of my committee. This bill, SB 382, is my final two-party consent bill for this session. As you know, you heard the other bills this week on Tuesday. It may be the most important for some because it allows the audio recording to be used as evidence in a criminal proceeding. It does not move Maryland to a one-party consent state. Rather, this preserves our standing as a two-party consent with the safety valve for victims of crime. There is notably some opposition from the Maryland domestic violence groups who are afraid about what legal advice to give to clients who ask whether they can record audio of their abuse. And I would dare say challenge my friends to supply solid evidence of this as a problem in a one-party consent states where this issue would be moot. There are always gives and takes with policy choices, but supporting the best evidence is usually common touchstone in the legal community. And this bill merely codifies an existing rule or what is known as a residual hearsay rule, Rule 5-803B24 in the context of audio recordings where one party is part of the conversation. Manipulating truth is something abusers, they always do, but it's harder to accomplish when you have an audio evidence that can be admissible in a criminal proceeding. Prosecutors help determine the truth as their job it requires by saying that they can't determine if the evidence is reliable and would turn it around on the victim, is to show little faith in these professionals. And there are larger issues to discuss here. This is a critical tool in our tool belt, and that is currently missing right now. And we don't need to move to a one-party consent to have this tool. But without this measure, we are in a creek without a paddle with victims' lives at stake. With all the talk of fighting crime in Maryland, I hope common sense measures such as this are considered, and they are considered as a tip of the spear, and our Dole Lake could be used more sharpening as we see it. This measure, of course, isn't perfect, but it is far much an improvement from the current status quo, where criminals are getting away with crimes and some convicted wrongfully because the evidence isn't admissible. The pendulum swings both ways, but the arc towards justice can only occur when we look outside our blinders to how we do things in Maryland and to look to laboratories of democracy around us to find a middle path for Maryland. We must do all that we can to help. This legislation is a sign of that vigilance towards justice and privacy. I'm open to amendments, of course, to this bill, especially in light of other related legislations moving simultaneously. This bill could be limited to criminal proceedings, but it does seem odd that if the evidence was admitted during a criminal proceeding, if that alleviates concerns in regard to this bill, I'm open to that change, and we can work on the civil proceedings issues in my other bill, SB 375. The physical note in SB 375 highlighted that there were 20 or fewer charges filed per year under section 10-402 of the criminal law article, which deals with interception of communications, resulting in no convictions. While women's advocacy groups consult with many victims of crime, it would be to think that they talk to every victim and advise them all not to audio record per existing law. And of course, even if they did, certainly some people wouldn't follow that advice. So why were no people convicted of this crime now? Perhaps because of the prosecutorial discretion. That fact should alleviate concerns of the victims, where in one-party consent states was evidence brought improperly and would serve as an example for us in Maryland. The true concerns involve, of course, providing legal advice in these nuanced circumstances, but the status quo is nuanced as well. When do you get prosecuted for violating two-party consent? The real question we should be asking, of course, is we don't have a clear response to this question. What opportunities are lost to prosecute criminals if we don't have this tool? How many lives are ruined because of our failure to arm our prosecutors with this lifeline in many cases? How many guilty people go free and innocent people are found guilty for our failure to see outside of our state's annotated laws? We want to catch up with technology for victims of crime and justice for all. For those reasons, I ask my colleagues a favorable vote on SB 382. I'd like to turn it over to my panel of witnesses. Thank you, Mr. Chairman.
Excellent. Thank you very much, Senator Lee. And we'll now move on to your panel. And first up is Ms. David. Welcome.
Thank you so much, Mr. Chairman, and thank you, members of the Judicial Proceedings Committee. My name is Sarah David, and I'm Deputy State Prosecutor at the Maryland Office of the State Prosecutor, here to support Senate Bill 382. Thank you so much, Senator Lee, for sponsoring this bill to help victims of violence, particularly those who've had historical challenges of being believed in our justice system. This legislation offers an avenue for admissibility for illegally recorded conversations. The general exclusionary rules, say from a Fourth Amendment violation, has exceptions, such as a good faith reliance on a warrant. The exclusionary rules that relates to a wiretap violation has no exceptions. Even if the evidence, if the recording consisted of a victim who was recording his own murder, a child recording his own sexual abuse, or recently in Baltimore County, a woman who recorded her own rape. The language for this exception to the wiretap exclusionary rule already exists in Maryland law, as Senator Lee alluded to, through the hearsay rule. Hearsay is an out-of-court statement that is offered for the truth of the matter asserted. There are exceptions for statements where circumstances of those statements are made in a situation that is more reliable or would go against somebody's interests or what they're observing at a time, very much in line with the reliability of an audio recording. So the language in this legislation is the same as the exemptions that allow hearsay rules in when there's not a specific exception that applies, which is called the residual hearsay, where a judge may admit the statement if it falls under enumerated exceptions. So this language makes it not so that all recordings are admissible if they violate the wiretap rule, but they can be admissible if the person who's offering the evidence can show that, one, the evidence is a material fact in a criminal proceeding, that the contents are more probative than other evidence the party entering the evidence could get, and the interest of justice would be served by the evidence being admitted, and the evidence has to be disclosed to the opposing party sufficiently in advance of trial. This standard ensures that parties cannot rely on wiretap evidence to be automatically admissible and still dissuades individuals from engaging in secret recordings, but would allow for situations where the interest of justice allows to be considered for admission. So thank you for your consideration of SB 382, and we encourage a favorable report.
Excellent. Thank you very much. All right. We'll now move on to Mr. Seltzer. Welcome back. There you go.
Good afternoon, Mr. Chairman. Can everyone hear me?
We can.
Okay, great. My name is Yosefi Seltzer. I'm an attorney at Fort Meade, and I'm speaking today in support of Senate Bill 382 on behalf of my clients who are victims of domestic violence. The current all-party consent law creates a chilling effect that intimidates victims of domestic violence from coming forward. I'm going to use the balance of my time to address the opponent's comments. Questions were raised as to how the attorney should advise clients who intend to make a recording. Like many other questions clients pose, attorneys have to explain the law and encourage the client to follow it. If this bill and SB 375 pass, making recordings would be admissible and the client can be advised accordingly. Going further, I believe the attorney has a responsibility to advise the client in their best interest, and if a recording would be legal and admissible, the client should make the recording to prevent further danger while also helping to bring the abuser to justice. Here's a similar example. The client asks, can I purchase a gun to protect myself from my abusive husband? In addition to discussing safe houses and protective orders, the attorney should explain the law, advising the client how the weapon could be used legally and not to use the gun illegally. It's responsible counseling. As to whether the attorney has to report the existence of the client's audio recording, that would be protected by attorney-client privilege and cannot be disclosed without the client's consent. The public defender's opposition to this bill and SB 375 is obvious. They know that admitting corroborating audio recordings would be a game changer because they could no longer challenge the victim's credibility. It no longer is a he said, she said situation. Finally, citizens should be encouraged to protect their personal safety using a recording device. The police are short-staffed. Moreover, we have all witnessed recent examples of how brave citizens made recordings of violent acts and disclosed them to achieve justice. This legislation uses the same peaceful means. We have refined the legislation based on feedback we received from this committee. Admitting audio recordings in domestic violence cases is working in more than 37 states, federal and military courts. If it was backfiring and actually harming victims, there would be a nationwide effort to reverse course on audio recording admissibility. That isn't happening. It is long overdue that Maryland take this important step forward to address domestic violence by lighting a candle rather than cursing the darkness. Thank you for your attention, and I welcome your questions.
Really eloquent testimony today, filled with lots of metaphors and lofty symbology today. It's great. All right, we'll go on for next we'll have Ms. Bailey. You're up.
Good afternoon, Mr. Chairman and members of the committee. As
you may recall from Tuesday's testimony, I am a attorney with the Legal Assistance Office at Fort Meade. I'm a domestic violence specialist there, where we have launched a new program to provide in-court representation to victims of domestic violence. I have been practicing for approximately 27 years, and most of that representing individuals in protective order cases and family law cases. And I'm not going to reiterate the very able testimony of my colleague, Mr. Seltzer, but I just wanted to, again, indicate my support for Senate Bill 382 and request that the committee give it a favorable report, and I am here and available for any questions the committee might have.
Excellent. Thank you very much. All right. See, Mr. McCarthy's here. Mr. McCarthy, go through. There you are. Go for your next.
Thank you very much, Chairman Smith. It's an honor to be with you again. Thank you, Senator Lee, for sponsoring this bill. I'm here speaking as a state's attorney for Montgomery County in strong support of Senate Bill 382 and urge a favorable report. Look, again, this is broader than this bill. This bill has been narrowly tailored to address very specific circumstances in criminal matters. I will just on a broader note in passing say to you that the 10402C criminal statute is completely out of date. It's not used as was indicated by prior testimony. I've only been practicing 40 years. I'm waiting for a single person to ever be prosecuted for a violation of this. What is left because this exception, we are carving out an exception in an area of criminal law that never gets used. All it does is chill victims of crimes from coming forward. And this happens just earlier this week on Tuesday. I went to a bench bar meeting here in Montgomery County, and it was lawyers practicing domestic law who many times are confronted with this particular problem, not knowing how to advise their clients, but it comes up all the time. People do have tapes of what's happened. It's the best evidence. This is a common sense way to bring greater protection to the victims of domestic violence. It's very limited. It doesn't totally abrogate 10402C, even though I will tell you, I think everybody would probably say, we don't want that. We don't want that authority to prosecute. We are here only in the area of stalking and domestic violence and crimes of violence. It's a common sense bill, and it's measured. It's measured because a judge has to make a determination that this is the best evidence that can be produced about this. So it's not the he said, she said. And the other thing in terms of ultimate fairness to the defense, there is a disclosure requirement. Now, we would provide this in discovery anyway, but in any instance, again, the law is doubling down and making sure that anyone against whom this evidence would ever be used is giving fair and adequate notification of that information well in advance of the trial. Again, I think this is a common sense approach, and I think it will save lives. And I urge a favorable report from this committee on Senate Bill 382. Thank you.
Excellent. Thank you very much, Mr. McCarthy. Good to see you. All right, we'll go on to Mr. Riley next.
Thank you, Chair Smith, distinguished members of the Judicial Proceedings Committee. My name is Joe Riley. I am the elected state's attorney for Caroline County and the legislative chair of the Maryland States Attorneys Association. We seek a favorable report on Senate Bill 382, and we would like to thank Senator Lee for her continued strong advocacy for the rights of victims and survivors throughout the state of Maryland. For those of you who may be reluctant to vote in favor of this bill, I would encourage you to look at it as a harm reduction type of bill. And I say that because when we train forensic examiners, we tell them to only interview their survivors one time. Why is that? Because further interviews will harm the survivor. They are damaging every time they have to relive those events. And what we do when we have a trial and have to put someone on the stand and talk about those events does cause trauma. I'll tell you about a case that I had specifically 3 years ago, where we had a young woman who was a high school student who recorded her guardian who was sexually abusing her for a decade and recorded him confessing to the event. All the evidence was brought to me. I reviewed it and had to have the unfortunate conversation that that recording was inadmissible in a court of law in the state of Maryland because of the way it was recorded. And we had to have a serious discussion about how we would proceed. Now, she elected to go forward, but it was a traumatizing event for her, to be sure, to detail these events. So I would encourage all the senators here to stop causing harm to victims and survivors of sexual assault and domestic violence, and be on the right side of this bill and vote in favor of Senate Bill 382. Thank you.
Excellent. Thank you very much. All right. Now we'll go on to Ms. Garth.
Good afternoon, Mr. Chairman and members of the committee. My name is Jessica Garth. I am the Chief of the Special Victims and Family Violence Unit at the State's Attorney's Office for Prince George's County. I want to thank Senator Lee again for bringing this bill forward. I think it is a very important one, and we are urging a favorable report on this bill. As the other panelists have already said, and I don't want to rehash what's already been testified to, but this really is just about being able to offer the best evidence in some of our worst cases. This bill provides an exception for crimes of violence, for violations of the protective order, and for stalking cases. And I don't know if you've ever been in a situation or ever seen cases like this, but under the current legal regime, for example, a violation of a protective order, where the defendant has threatened the victim, currently the testimony that could be offered would be the victim's testimony to the court, her oral testimony. If this bill is passed, she would be able to record that threat, to play that threat to the judge or to the jury. And I have to tell you that, hearing the threat, hearing the actual words, hearing the tone has a much bigger impact on the case and has a much bigger impact on getting justice for our victims. Now, this bill is important in other cases, other than violations of a protective order. I can tell you that right now we have a rape case in my unit where the victim has an entire conversation with the alleged rapist after the rape has occurred. Under the current legal regime, that conversation isn't admissible. So all this bill would do is really create a limited exception, which still protects our two-party consent laws, but allows this important evidence to come in some of our most serious cases. I want to thank you again for your attention, and I again urge a favorable report on this bill.
Thank you very much, Ms. Garth. All right, next we'll move on to Ms. Carpenter. Welcome.
Good afternoon, Chairman Smith, members of the committee. My name is Lindsay Carpenter. I'm a prosecutor in the Special Victims Unit in Frederick County. I'm here on behalf of MSAA and the Frederick County State's Attorney's Office requesting a favorable report on SB 382. As a prosecutor, I always tell my victims and witnesses that I'm for the truth. That is my job, to find the truth and then determine whether or not an individual has violated the law, and if they have, hold them accountable for those violations. What better way to determine the truth than to see a video or audio recording of a violent crime? The reality is these recordings already exist, and when they come into our possession, it's unfortunate that we're unable to provide them to the finder of fact, whose job it is to also find the truth in determining whether or not to convict an individual. This bill would allow us to present those items in evidence if certain safeguards are established. Furthermore, if there are concerns regarding potential tampering or altering of videos or recordings, the rules of evidence already address those concerns. Only evidence which is relevant and reliable is currently admissible in court. We have seen these recordings in cases of felony child abuse, domestic violence, and sexual assault cases, which many times are he said, she said cases. Having a recording would ensure that the fact finder knows the truth. On behalf of those victims, I urge this committee to support our most vulnerable and issue a favorable report on SB 382.
Excellent. Thank you very much, Ms. Carpenter. Right, and with that, that'll conclude the testimony for Senate Bill 382. We'll now switch it over to the committee for questions. All right, seeing no questions, thank you, Senator Lee, and to your panelists. Thank you all. That'll conclude the hearing for Senate Bill 382. We'll now move on to Senate Bill 356. Senator West, are you ready? Awesome.
Yes, I am. Thank you.
All right.
Chairman. So as Abraham Lincoln once said, human action can be modified to some extent, but human nature cannot be changed. This bill is sort of about human nature. So under Maryland law, in many situations, a person is eligible to have all police records and court records of an offense expunged. But there are exceptions contained in Section 10-105E of the criminal procedure article. This bill creates 2 additional exceptions. It's an exceedingly simple bill. It's basically 2 sentences long. First, a person would not be entitled to expungement if the court ordered the person to register as a sex offender under Title 11, Subtitle 7 of the Criminal Law article in connection with the disposition of the charge on which the petition to expunge is based. In other words, we should not allow a person to expunge the offense if that would also carry with it the expungement of the requirement that the person register as a sex offender. Secondly, a person would not be entitled to an expungement if the person has not satisfied an obligation to pay court costs, fines, or restitution that the court imposed in connection with the disposition of the charge on which the petition to expunge is based. So if the person has not done what the court ordered the person to do, why in the world would we want to allow the person to expunge the offense for which the person was convicted? So if the petitioner for an expungement had been ordered to register as a sex offender, or if the petitioner has not paid the court costs, fees, and restitution, indicating he doesn't have remorse and he doesn't really intend to reform himself, the petitioner should not be entitled to an expungement of those offenses. And I'm going to give you now John Cox, who's with the Baltimore County State's Attorney's Office, who can further explain the nature of this bill and the reason why it's so important.
Thank you very much, Senator. And we'll now switch over to Mr. Cox. Is Mr. Cox here? I don't see Mr. Cox here.
Good here.
We're going to
I
go
don't
on.
see him either.
So we're going to go to
Okay.
Ms. Jordan is here. So we'll go down to Ms. Jordan.
Thank you. Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here to support Senate Bill 435, no, not 435, sorry. 356, sorry about that, and ask for a favorable report. You know, this really is a pretty straightforward bill, and I was just going to submit written testimony, and Senator West asked that I testify, and I'm certainly happy to do so. But you have such a strong public policy in Maryland about sex offender registry and putting people on the sex offender registry. And it really is inconsistent to say, on the one hand, that we need to have people on the sex offender registry, and then on the other hand, that we're going to allow them to completely expunge their record and deprive the public of the basis for the reason for the registry. So that's the issue that is of most concern to the Maryland Coalition Against Sexual Assault. Regarding the remainder of the bill, for the Coalition Against Sexual Assault, restitution is really the issue that speaks to our clients the most vividly. If someone is ordered to pay restitution for counseling, for injuries that have been inflicted, those sorts of things, allowing them to get off the hook because of that, because they're getting things expunged, is really depriving that victim of justice under the criminal justice system. Regarding court costs and other fines, certainly I do want to acknowledge that we don't want to criminalize poverty, and there are some more difficult issues there. I would ask you to consider, though, that court costs are part of what supports victim services in Maryland. So if you are going to allow people to get out of court costs by expunging their records, you're also going to need to look at some other way to support those costs. I am confident that that State's Attorney Cox would have some additional views on this and may be able to add some additional perspectives on court costs and fines. But certainly for the Coalition Against Sexual Assault, we urge a favorable report, particularly regarding the sex offender registry and regarding restitution.
Excellent. Thank you very much, Ms. Jordan. And now that'll conclude the testimony for the proponents of the bill. We'll switch over to the opposition panel. Just for the committee, I'm looking at, so Mr. Cox did submit written testimony that's in our file, so you can access it there. Now we'll go with Ms. Hanson Mundell.
Good afternoon. For the record, Nicole Hanson Mundell, Executive Director of Out for Justice, an organization that advocates for individuals with criminal records, right? And that includes all people with criminal records. Some of our concerns are really connected to the fines and fees, in which my fellow advocate, Ms. Jordan, alluded to, which is the the borderline between impacting the criminalization of poverty, right? Those with more income and more connections to people with money can pay their debts and will have a greater access to expungement. And those who have less won't, right? And the unequal access to expungement according to income would really disproportionately impact groups who, on average, face systematic barriers to growing incomes and wealth, including but not limited to women, Black and Latino people, and members of the LGBT community. This bill will multiply the above disparities according to income, race, and gender and sexuality by limiting access to future employment. Experimentally, audits have revealed that criminal record discrimination by employers is common, and this discrimination also has disproportionately negatively impacts on Black and Brown Americans. And the last thing I'll note, just please let me get this out, Mr. Chair, is that this kind of removes the idea of the different levels of sex offenses, right? We have 18-year-olds who have a relationship with a 17-year-old, and because of the laws or whatever, they somehow end up on a sex offender list, right? It excludes those different levels in which people end up on a sex offender list. We have people who have been sex trafficked and have end up on the sex offender list from prior offenses in the prior years. So I would caution to look at the levels and use kind of just some a little bit more of an eye on the type of offense as opposed to just labeling all sex offenses, because as advocates know, there are different mitigating factors that go into how people end up with certain sex offenses.
Excellent. Thank you very much.
I hope that makes sense.
Good. So we've got next, we'll have, is Ms. Smith here? All right. So then we'll now move on to Mr. Dews. There you go.
Thank you. My name is Christopher Dews, and I'm the Senior Policy Advocate for the Job Opportunities Task Force, where our mission, as always, is to help lower wage workers advance to higher wage jobs, mostly by eliminating barriers to employment. And as such, we have to oppose Senate Bill 356 as a means of decriminalizing poverty, as has already been mentioned, and reducing barriers to employment. As has already been established, the criminal record can be both the cause and consequence of poverty. Lower income workers and job seekers are routinely denied employment about 85% of the times because they have a criminal record and they are just blocked. They're not allowed to it. Also, housing, educational opportunities, occupational licensing, and access to public assistance is also blocked from a criminal record. As employment barriers increase for people with records, so too does the likelihood of recidivism, which is a conversation we are consistently having right now in the state of Maryland. With Maryland Case Search allowing one's information to be put on public view, it becomes a massive problem for hiring decisions. So for us, this bill, it has to take into account the fines and fees section. That's our number one concern. It doesn't take into account the defendant's ability to pay. The imposed fines offers no payment plan and assumes that preventing the expungement will somehow incentivize payments. As was stated before, criminal records block access to employment, and with that, the wages needed to pay fines. As the majority of those who have interactions with the criminal justice system tend to be indigent individuals, this bill effectively ensures that they remain impoverished with no avenue to rise. Not to mention the fact that the Central Collections Unit charges an additional 17% on average of interest and late fees for inability to pay court fines and fees. So if the argument is really about sexual offenses, I agree 100% with my colleague, Nicole Hanson. There are levels to that game, but I would say that the bill, that's a separate bill altogether, and that those issues should be kind of split apart. I would even offer an amendment to get rid of lines 3 through 5 on page 4. If we're looking at restitution as the issue, which I can somewhat understand, I would suggest is getting rid of the first 4 lines of page 4. I think that would make this bill a lot more feasible when looking at that issue. However, I will say If you don't work, you don't eat. Yeah, we got to give people access to employment. And so we think this bill is going to block that with regards to expungements. I thank you all for listening.
So thank you very much, Mr. Dews. All right, well, that concludes the testimony for Senate Bill 356. We'll now move on to questions from the committee. And we've got Jill Carter, Senator Carter.
Thanks, Mr. Chair. I'm sorry, I missed the vote, Senator West. And I think I should have asked this of you before the opposing panel came. I just wanted to know if this is just kind of an exercise in anticipatory difficulties, or do you have any concrete examples of where this has actually been a thing?
Senator Carter, that's why I was hoping that Mr. Cox was going to be here, because the Baltimore County State's Attorney's Office has had examples of this, but unfortunately he's not with us. So I will see if I can't get from him some sort of a letter explaining or setting forth the examples and provide it to you.
Thank you.
Sure.
Excellent. All right, looking for the committee for additional questions. Seeing none, that'll conclude the hearing for Senate Bill 356. Thank you, Senator West, and to the panelists. We'll now move on to Senator Huff with Senate Bill 339. Senator Huff, you're up.
Thank you very much, Mr. Chair. The committee will be very much familiar with this legislation, as it is exactly the same posture as the crime bill we passed last year. This legislation is a result of hard work that this committee put in strengthening our penalties against crimes of violence by those using firearms. And these penalties are targeted specifically at repeat offenders. I should note there are no mandatory minimums in this bill. Instead, this bill increases the maximum penalty allowed. We passed this out of committee and has passed the Maryland Senate in 2021 and 2020. Unfortunately, it's never been given the courtesy of even a hearing in the House. Just like the bill was offered in prior years, this is a bill because gun homicides continue to be at unacceptably high levels in our state, and Marylanders, quite frankly, are demanding action. We see unacceptably high levels of homicide, not only in the city of Baltimore, but throughout the state. In my county, which would, in past years, have an average of 1 to 2 homicides, already this year, we saw a 21-year-old man was killed by another 20-year-old in December. Recently, a 21-year-old woman was murdered on January 10th in Frederick, and her body was found in a wooded area. In Howard County, which is had been a relatively safe community up to recently, these are just recent headlines. A man was killed just this past Saturday in Columbia, and a double homicide occurred in Ellicott City this past September. In Montgomery County, saw an 88% increase in homicides and a 72% increase in carjackings in 2021. 2021 continued to be one of the deadliest years on record was the deadliest year on record for Baltimore County. Prince George's County is at a 14-year high with violent crime. It saw a rise in homicides with 108 in 2021 and carjackings at 152 in 2021. WBL News Radio reported that January 2022 was the deadliest January ever in the city of Baltimore. There's been a number of heinous acts of note recently in Baltimore, where a beloved manager of a restaurant, Little Italy, was murdered. And the same night, also a 51-year-old mother of 3 who was working for DoorDash, was heinously murdered. These shootings and murders are happening in broad daylight to innocent and law-abiding people. It should be noted that a poll commissioned by Governor Hogan showed that these are broadly popular among Marylanders. His proposal to increase tougher sentences for violent offenders with guns has 81% of support among Marylanders. Among Democrats, 80%, with 61% strongly for it. The victims of these crimes are not receiving justice. Honest citizens now live under increased fear of unchecked violent criminals. Illegal handguns are the problem, along with not prosecuting repeat violent offenders. Criminals are using and repeatedly carrying firearms to commit these violent acts. 81.4% of homicide suspects in Baltimore City had prior records, and 44% of suspects had previous arrests for gun crimes. And I remember back in 2018, then Senator Norman asked then Baltimore City Police Commissioner Daryl DeSouza how many homicides have been committed in the city by lawfully obtained firearms. Commissioner DeSouza responded, quote, "None that I'm aware of." This bill is a package with many different elements to tackle violent crime in Maryland. First thing it does is it increases the penalty on repeat offenders committing violent crimes with guns. Second, it increases the minimum sentence for individuals who repeatedly use a firearm in the commission of a crime. 3, it establishes a reentry program for inmates before and after their release, and it provides inmates with reentry kit. 4, it permits the state to appeal to trial court decisions to exclude evidences in cases involving a firearm, including those involving major drug traffickers and drug kingpins. And I'll quote our chairman of our committee who eloquently defended this provision on the floor of the Senate 2 years ago. Quote, "This expands the opportunity for the state to file an interlocutory appeal on 15 offenses, all gun offenses where the person is a repeat offender. Motions to suppress are very rarely overturned. So if the state is going to go forward with this appeal, they have to be nearly certain that the trial judge made a mistake because there are checks," unquote. 5, it adds use of possession of a firearm to the list of offenses that cannot be considered technical offenses for parole probation. 6, it changes, sorry, automatic lights went out here. 6, it changes use of an assault weapon, rapid fire trigger activator, or magazine that has capacity more than 10 rounds in the commission of a felony or crime of violence from a misdemeanor to a felony. And it codifies the Wynn decision that says the firearm must be in use and not just mere possession. 7, it closes the drug dealer loophole. Currently is only a misdemeanor when a drug dealer uses a firearm while dealing drugs, whereas every other felony in the state of Maryland is an enhanced penalty. 8, it increases the penalties on people who are disqualified from owning firearms, such as fugitives and those with a history of violent behavior against themselves or others. Current law provides for a maximum penalty of 5 years for prohibited persons who illegally possess regulated firearms. This bill increases the maximum penalty for repeat offenders up to 10 years. 9, it adds to the law that a dealer or other person may not sell, rent, loan, transfer a regulated firearm to a purchaser, leasee, borrower, or transferee if the dealer or person has, quote, actual knowledge that the purchaser, leasee, borrower, or transferee intends to use the firearm to commit a crime, cause harm to others. We know crime by repeat offenders using firearms is out of control in our communities. The public knows it too. They see it every day on their airwaves. And overwhelmingly, the public wants tougher laws against these criminals to keep them off the streets and to make our neighborhoods safe again. It is past time for us to take action. Because of this, we have in the past, this committee and the Senate took action and passed this on the floor repeatedly. It is past time that we get this signed into law and enacted immediately to start bringing a halt to these tragic murders. For all these reasons, I urge a favorable report on Senate Bill 339.
Thank you very much, Senator Huff. So we'll now go on to your panel. First up, we have Mr. Riley.
Thank you, Chair Smith, Vice Chair Wallstreicher, distinguished members of the Judicial Proceedings Committee. My name is Joe Riley. I'm the elected State's Attorney for Caroline County and the Legislative Chair for the Maryland States Attorneys Association. We seek a favorable report on Senate Bill 339 and I'd like to thank Senator Huff for bringing forward this important piece of legislation. Incredibly thorough testimony by the sponsor, not really going to follow up and take too much of your time, but just would encourage you to look at how this bill is titled. An emergency bill. The gun violence that is going on in our state is an emergency and it needs to be addressed. The members of this committee are the people who have the tools to address it, and we are asking you to do so. Thank you, and I'll answer any questions that you have on the bill.
Excellent. Thank you very much. All right. That will conclude the testimony for the proponents of the bill. We'll now switch over to the opposition panel, and we'll start off with Ms. Hilliard.
Thank you, Mr. Chair, members of the committee. I know it's been a long day. I will try to be brief. Elizabeth Hilliard with the Maryland Office of the Public Defender. The Maryland Office of the Public Defender urges an unfavorable report on this bill because it has a good intent, but poor execution. It's an unfortunate step in the wrong direction based on failed policies that have undermined public safety and community stability for decades. Legislative proposals of this magnitude should be supported by research and data to demonstrate that they will ensure the effect that is purported. Public safety. It's stated that this is a common sense measure to combat crime, but there's no empirical data or evidence to show that enhancing criminal penalties and increasing lengths of incarceration significantly deter or reduces crime. In fact, research and data show the opposite. Harsh criminal penalties do not deter crime or prevent recidivism, and tough on crime policies do not make our communities safer. I will also note and slightly disagree with Senator Huff that although there is not a mandatory minimum penalty outlined in this bill itself, adding or subtracting drug dealer exception from the felony use of a firearm in the commission of a felony in 14101 does subject that crime to the mandatory minimums outlined in 14101. So it does effectuate a mandatory minimum in that instance. And further, it's duplicative of existing law. We already have Maryland criminal law 5621, which is meant to prosecute persons who are using drugs within drug trafficking nexus. We already have laws against violent offenses involving handguns. This is duplicative, unnecessary, and it's just not good policy. Accordingly, the Maryland Office of the Public Defender urges an unfavorable report on this bill. Thank you.
Excellent. Thank you very much, Ms. Hilliard. And we'll now move on to, let's see, is Ms. Hanson Mundell still here? You're up next. All right, we'll go on to Mr. Grand Prix. You're up. There you go.
Hello, can you hear me?
We can. Welcome.
Yes, Lawrence Grand Prix, Director of Research for Leaders of a Beautiful Struggle. I'm against SB 339 for 3 reasons. First, my experience as a researcher. Second, my experience as a victim of crime. And third, my experience as a son of a cop. So as a researcher, John Pass, of the University of Law Fordham, says that it's not nonviolent drug offenders that drive mass incarceration. It's actually the long sentences we give to relatively minor crimes. So I know folks don't feel like these type of bills feed mass incarceration, but Pass tells me that this is actually how it is accomplished. Michael Muller-Smith at Michigan, he writes the following, quote, "The empirical results indicate that incarceration generates net increases in the frequency and severity of recidivism, worsens labor market outcomes, and strengthens dependency on public assistance. Short-run gains are more than offset by long-term increases in post-release criminal behavior. Incarceration encourages more serious offenses." So what's happening here? Let's start with the so-called street organizations or gangs. If you're in a street organization, you need somebody with a gun, somebody gets locked up, you just recruit another person. It's a conveyor belt effect. So the long sentences don't deter crime in that way. This is actually what Muller-Smith is seeing in his research, because when a person is locked up for a long period of time, they come out without the connection to community needed to transition out of criminal life. So they're more likely to recidivate, and the young person who replaces them is now in the gang. So secondly, it's important to remember, most of these people are not actually gang affiliated. These are people who might carry a gun because they're in cash industries, party promotion, contractors, and they need a deterrent because they can't afford to get robbed. These are people who can't have legal guns because of over-policing in their communities, and they're the ones that get swept up, because we all know the shot callers, the hitters, they don't carry guns because they're previously stayed upon already existing mandatory minimums. Secondly, as a victim of crime, Preakness 2019, I was actually the victim of armed robbery. And I actually had to go around downtown finding something to buy to give this person so they could get the gun off of me. And what I realized is that this is Preakness. This is periods of the highest levels of police saturation. And if this can't deter crime and the hunger to actually talk to the brother, the hunger he talked about feeding his family when he just got out, this isn't going to deter crime either. And finally, I know I'm running out of time. I'm the son of a cop, 20 years BPD undercover. He told me that the war on drugs taught a generation of cops how to not do the job, not cultivate community relationships, not cultivate CIs, confidential informants, and these type of bills that increase mandatory minimums make it so folks never learn how to actually do the work that actually allows us to deter the small segments of our community that actually drive the violence. So I urge an unfavorable report. Thank you.
Thank you very much. All right. Our last, is Ms. Smith here? Ms. Smith is not here. Is that right? Okay.
That's
Well,
correct.
now we'll go to Ms. Hanson Mundell. Ms. Hanson Mundell, stay on time. All right. There we go.
Thank you. I apologize. Nicole Hanson Mundell, Out for Justice, an organization that is impacted by this specific bill itself, individuals who happen to find themselves on the other side of the criminal legal system. Just like include some token support and benefits to people taken into legal system and incarceration, but these amounts to gestures towards justice, and they do not outweigh the harm caused by this bill. This bill is still a move backwards for Maryland towards mass incarceration. The state has touted its decreasing correctional population, and this will reverse that progress. It pulls individuals back to, for people who have made an additional mistake for a number of reasons, these harsh sentences will pull them away from their communities and families. Labeling someone with a felony as opposed to a misdemeanor can increase their likelihood of recidivism, even more so among women, right? And this is data that proves it. It really inserts more partisan politics into the criminal legal system by giving the state more power to appeal court decisions, to exclude evidence. Incarceration is doing harm, not good. It's tackled down effects with communities, separating us from parents and our children. And it has a higher likelihood of incarceration for children, taking skilled people out of communities, causing more psychological pain for families. The governor is not focusing on ensuring that incarcerated people have access to the best supports while incarcerated and afterwards. The longer individuals are incarcerated, the harder is it for them to rejoin community as productive citizens. And like every piece of legislation like this, I will say, instead of providing healing and support, and instead of providing the funds to a thing called women's pre-release, he decides to introduce legislation like this. And so what we'll say is fund pre-release, fund an idea that supports impacted women coming into our communities and are able to lead productive lives. That is a part of the solution.
Thank you, Ms. Mundell. Thank you. Excellent. Thank you very much. All right, so that will then conclude the testimony for Senate Bill 339, and now I'll switch over to the committee for questions. Seeing no questions, just before we close out today, I'm going to say the quiet part out loud. There has been a lack and a dearth of intellectual honesty with regard to how we're regulating and dealing with firearms and gun safety. You know, we've passed bills for the long gun, for safe storage. We're going to do ghost guns this year. And I don't see folks showing up, the same folks that are opposing this bill showing up to oppose those bills, even though they implement strong penalties. So too is the case that folks that say that they're interested in gun safety don't come in on the long gun bill, don't come in on safe storage, don't help us with that process. I just think that we've got to step back and both sides have got to come together on this, because it's just intellectually dishonest the way we're talking about this. And we've put penalties on the books for guns in one way, but not the other. And I just think like it's just such an intellectually dishonest conversation. It's frustrating to me. And I just challenge the folks in this committee and on the Senate floor to just have that open and intellectually honest conversation about this. Now, look, this bill in particular, a version of this bill, and I'm not saying I'm supporting it this year, but this bill was on the floor, and I thought we had a most unfortunate conversation surrounding it, because the week prior, people had voted to make the unlicensed practice of dentistry a felony. And then we had this conversation. So there's something that's just incongruent and inconsistent with the conversation. And I just would challenge all of us to just step up, like level up our game when we're talking about this issue, because it's just been very inconsistent and frustrating. So with that, that'll conclude the hearing for Senate Bill 339 and our hearings for today. I'll see you all tomorrow at 9:30 for voting.